right, Kim Mitchell. We'll go when you say.
I'm ready when you are. Thank you.
All right. Great. Good morning, everyone. Let's come to order. I am Commissioner Dan Clodfelder, and I have been assigned to preside during this proceeding. Joining me this morning via remote connection are Commissioners Brown Bland, Commissioner Gray, Commissioner Duffley, Commissioner Hughes, and Commissioner McKissick. We're now going to bring for hearing docket numbers E-2 sub 1177 and E-7 sub 1172, which are the complaints of Cube Yadkin Generation LLC against Duke Energy Progress and Duke Energy Carolinas, respectively. These matters are on remand to the Commission from a decision by the North Carolina Court of Appeals. In compliance with the requirement of the State Ethics Act, I remind all the commissioners of our duty to avoid conflicts of interest, and at this time inquire whether any member of the Commission has a known conflict of interest with respect to these matters. Madam Court Reporter, no conflicts were indicated, and let the record please so note. On July 16th, 2018, the Commission issued an order granting the Duke Utilities motion to dismiss Cube Yadkin's complaints in these dockets. Cube Yadkin thereafter appealed, and on December 17th, 2019, the Court of Appeals issued its opinion affirming in part and reversing in part the Commission's order and remanding these dockets to the Commission for further proceedings on the question of whether Cube Yadkin should be granted a waiver of the requirement that it submit a notice of commitment form in order to establish a legally enforceable obligation as a QF under PURPA. On December 14, 2020, Cube Yadkin filed direct testimony of John Collins, consisting of 14 pages and 5 exhibits, 2 of which were filed as confidential. On January 15, 2021, the 2 Duke utilities filed the direct testimony and exhibits of Glenn Snyder, consisting of 10 pages, but no exhibits, and Michael Keene, consisting of 18 pages, 1 page of which contained confidential information, and 4 exhibits. On February 16, Cube Yadkin filed a rebuttal testimony and exhibits of witness John Collins, consisting of 17 pages, including 6 exhibits designated as confidential. Also on February 16th this year, Cube Yadkin and the 2 Duke utilities filed their consents that this hearing could be conducted by remote means. I know we've got a couple of brief preliminary matters to address, and I understand at least one of the parties wants to make a short opening statement. So let me first ask for appearances of counsel. Mr. Snowden, we'll start with you.
Good morning, Presiding Commissioner Clodfelter, members of the Commission. I'm Ben Snowden with the law firm of Kilpatrick, Townsend, and Stockton, here on behalf of Cube Yadkin Generation LLC. Also here on behalf of Cube are my colleagues, Joe Dowdy and Philip Harris.
Great, good morning. Ms. Fentress, Mr. Taylor, I'm not sure which of you is leading this one, so I'll call on whoever wants to speak.
I'll let Kendrick go.
That would be me this morning, Commissioner Clodfelter. Good morning, Commissioner Clodfelter, Commissioners. I'm Kendrick Fentress. I'm appearing on behalf of Duke Energy Carolinas and Duke Energy Progress in this proceeding. I think if Cube is going to make an opening statement, we would like to do so as well. I'll just say that. And also I'll turn it to Mr. Kaler and he can introduce himself today.
Thank you. Chair, members of the Commission, Robert Kaler appearing on behalf of Duke Energy Progress and Duke Energy Carolinas.
Great. Anyone else appearing in the case? All right. I know that you've all been briefed by the Commission's counsel on the procedures for conducting the hearing remotely. I want to just offer a couple of supplements to what I know you've already been told. I have you all on the screen before me in grid view. If you need to be recognized for any purpose during the hearing, please call out your name so I can find you at the right place on the screen and don't have to go hunting for you. That will help me out tremendously. I understand we only have 3 witnesses for the hearing today, Mr. Collins for the complainant, and Mr. Snyder and Mr. Keene, who will testify as a panel for the Duke Utilities. I want to be sure that all of those witnesses have available to them now, either in electronic form or in hard copy, a complete set of all the potential exhibits that may be used on cross-examination or redirect. So we can not have to spend time during the course of the hearing hunting down an exhibit so the witness has it. Mr. Snowden, Ms. Fentress, can you confirm that your witnesses all have access either electronically or in hard copy to all of the exhibits that might be used today?
Yes, sir.
They have
Yes,
been,
sir.
go ahead, Ben.
Sorry. Yes, sir, Mr. Commissioner, we have provided our witness with all the exhibits.
Great. That's good.
And we have provided our witnesses with those exhibits as well.
Excellently. We won't have to do any hunting around. Finally, before I get to matters that you may have, I understand that there has been an agreement or stipulation potentially among council to waive the confidentiality designation of all the exhibits that have been previously marked as confidential. I need to sort of confirm whether that is or is not the case, because of course, if we're going to be dealing with confidential matters, we'll have to break here and convene by telephone conference. So let me first find out if the information I've been giving is correct. My understanding is we won't be dealing with any confidential information or exhibits. Is that correct?
That is correct, sir, from CUBE's point of view.
Yes, Duke has no confidential information in this proceedings.
Excellent, excellent. Good progress. Okay, are there other preliminary, before we get to the opening statements, preliminary matters from the parties themselves? Ms. Fentress.
Yes, Commissioner Clodfelter, yesterday I sent an email containing an additional cross-examination exhibit to Cube Yatkin and sought their permission, or at least their agreement, that I could add this to our list of cross-examination exhibits. It is designated as attachment 9. It is a letter and a compliance filing made by the companies and docket number E100 sub 140. And I would now make a motion that the commission would accept that as one of the cross-examination exhibits for Duke Energy in this proceeding.
Okay, Mr. Snowden.
CUBE does not object to that motion.
All right, it will be added to the potential list of cross-examination exhibits.
Thank you.
Other preliminary matters? If not, then Mr. Snowden, brief, I understood you wanted a brief opening statement, and Ms. Fentress accordingly to you. So Mr. Snowden, briefly.
Yes, sir. And my colleague, Mr. Downey, will be delivering our opening statement much more.
Okay, excellent. Mr. Dowdy, your video is off. There you are.
It should be fixed now. Thank you.
Great.
Good morning, members of the commission. Thank you for hearing us today. This is a proceeding by Cube Yadkin Generation LLC requesting that the commission find that Cube had established a legally enforceable obligation for its 3 hydroelectric facilities no later than October 11, 2016. This will require the commission to grant a waiver of the notice of commitment form requirement generally required to establish a LEO. The Cube Yadkin facilities at issue are High Rock, Tuckertown, and Falls Station. They're located on the Yadkin River in western North Carolina, and they're long existing, well-known facilities, all of which were constructed well before the 1965 enactment of the CPCN requirement for construction of generating facilities. Cube contractually obligated itself to purchase the facilities on June 30th, 2016, when it entered into a purchase agreement for the 3 facilities, as well as a 4th facility, Narrows, which is not a QF and not an issue here. By September 2016, Alcoa and Cube were finalizing the transfer, and all that remained to be completed were standard regulatory items. By September 16, Alcoa and Cube also had prepared and filed with the Federal Energy Regulatory Commission a request to transfer the license for the facilities to Cube, and FERC issued an order transferring the license in December 2016. The parties fully finalized the purchase on February 1st, 2017. After Cube was contractually entitled and obligated to acquire the facilities, and while the transaction was awaiting final regulatory approvals, Cube reached out to Duke to begin serious discussions about a long-term PPA for the facility's output. This was done at Alcoa's suggestion and with its encouragement. The correspondence between Cube and Duke shows that Cube planned at a minimum to sell the output of the 3 facilities at issue to Duke under PURPA, though Cube felt there were advantages to the parties and the public if the parties contracted for PPAs for all 4 facilities. The correspondence demonstrates that as of October 11, 2016, CUBE's commitment of the 3 facilities' output was clear. There can be no doubt that Alcoa was cooperating because it self-certified the 3 facilities as QFs 1 week after Duke sent correspondence to CUBE in September 2016, noting that the facilities were not yet self-certified. As the incoming owner, CUBE could commit the facility's output, but it could not complete Duke's NOC form. That form requires the facility to indicate that it either has obtained or will obtain a CPCN, and it requires the seller to agree that its LEO date is the later date of either the NOC form submission date or the date on which the facility obtains a CPCN. If these facilities predated the CPCN requirement, the form would interfere with CUBE's ability to establish a LEO for the facilities. From the beginning, Duke has sought to avoid its PURPA obligations. Its present objection is based on the non-submission of the NOC form. But waiver is appropriate for several reasons. First, CUBE proceeded reasonably and in good faith in not completing the NOC form. As I indicated, Duke's NOC form assumes that a facility must obtain a CPCN and ties the LEO date to the issuance of the CPCN. And these facilities predate the CPCN requirement. Second, it appears Duke would not have accepted the NOC form from CUBE had CUBE submitted one, because perfunctory regulatory approvals of the sale from Alcoa were still pending. Third, and relatedly, CUBE was far more than a prospective or possible purchaser of the QFs when it committed their output. Its purchase of the QFs contractually obligated it to acquire the facilities once all the necessary regulatory approvals were completed, and Alcoa was cooperating with CUBE's efforts to obtain PPAs from Duke. Fourth, allowing CUBE a waiver from submitting the NOC form would be in the public and the ratepayers' best interest. The CUBE QFs would provide greater value to Duke than other QFs because the CUBE QFs are long-standing, reliable facilities that provide clean energy and ancillary services at lower or substantially the same cost to consumers as a Duke self-build. And CUBE is willing to provide dispatch rights to Duke, which would enable the output of the facilities to be coordinated with Duke's own downriver hydroelectric facilities, and thereby provide Duke more generation control and support for the integration of intermittent resources on Duke's transmission and distribution systems. Fifth, we respectfully submit that refusing a waiver would reward Duke for its efforts to avoid its PURPA obligations here. We appreciate your attention and look forward to presenting our case to you. Thank you very much for your time.
Thank you, Mr. Dowdy. Ms. Fentress?
Thank you, Commissioner Clodfelter. Duke Energy is here today standing in the shoes of our customers, our industrial customers, our residential customers, our commercial customers, our small business customers. And I say that because it is our customers who pay the avoided cost rates that are remitted to QFs. CUBE Yadkin is and has been, as Mr. Collins' testimony states, a highly capitalized, sophisticated market player with sophisticated and knowledgeable representatives. Yet they are here before the Commission today arguing that the Commission should waive its own clear, well-established requirements for establishing a LEO that ensures the avoided cost rates paid by our customers actually align with the company's avoided cost at the time. CUBE Yadkin's argument in support of this requested waiver is that this sophisticated, highly capitalized market player was unable to comply with the Commission's simple, clear requirements because they were unaware of them or because they were too difficult to comply with. So they have asked this Commission to instead retroactively select a self-serving date for CUBE prior to November 15th, 2016, to say that they have established a LEO. This time period that they refer to is actually before CUBE owned these assets, before CUBE operated these assets, before CUBE became a QF, which is one of the LEO requirements, basically before CUBE became a small power producer. The LEO requirements at issue in this docket were made by the Commission to protect our customers from the risk of overpayment for PURPA power, and under the circumstances of this case, CUBE has failed to justify its requested waiver. Thank you.
Thank you, Ms. Fentress. Anything else we need to take up before I turn the case over to Mr. Snowden? If
Mr.
not,
Chair,
yes.
in an abundance of caution, if this is the appropriate time, I was going to ask if the commission would take judicial notice of the complaint, the response, the filings in the complaint docket, as well as the commission's avoided cost orders in docket number E100 sub 140 and E100 sub 148. I believe testimony from the witnesses will refer to those dockets, and it just seemed appropriate to take judicial notice.
You may be doing Mr. Snowden's work for him, but I'm sure he doesn't object to that. And the commission will take judicial notice of the matters filed of record in this docket and also of its order in the sub 140 avoided cost docket. Was there anything else in your list?
The order in the sub 148 avoided cost proceeding.
I'm sorry, the 148 order, correct.
Both, yes, thank you.
All right, Mr. Snowden, that's all been taken care of for you, so you now have the case.
All right, thank you, Commissioner Clodfelter. I will turn it over to Mr. Harris to introduce our witness.
All right.
Good morning, Commissioner Clodfelter and members of the commission. We would like to call John Collins, please.
All right, Mr. Collins, if you'll please raise your right hand and affirm. Do you solemnly and sincerely affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Great. All right, Mr. Harris, you may proceed.
Thank you, Commissioner Clodfelter. Mr. Collins, would you please state your name and business address for the record?
My name is John R. Collins. My business address is 49 West Side Drive, Rehoboth Beach, Delaware, 19971.
By whom are you employed and in what capacity?
I'm employed by First State Advisors, LLC, which is a consulting firm, and I am the president and CEO.
Okay.
Previously, I was employed by Cube Hydro Partners, first as the executive vice president and then subsequently as the president and CEO.
Okay. And did you cause to be pre-filed in this docket on December 14th, 2020, 14 pages of direct testimony and 5 exhibits?
Yes, I did.
And do you have any corrections or changes to that testimony?
Yes, I do. On page 4, line 16 of the testimony, I stated that the license for the facilities was transferred by order in January 2017. That should have been on or about December 13, 2016. In addition, on page 7, lines 9 through 11, Alcoa's certification occurred on September 28, 2016, and on or about March 8, 2018, Cube filed revised Form 556 with FERC reflecting the change in ownership.
Okay. And with those changes, if I were to ask you the same questions that appear in your direct testimony today, would your answers otherwise be the same?
Yes.
All right, Presiding Commissioner Clodfelter, at this time, I move that the direct testimony of John Collins be copied into the record as if given orally from the stand, and his exhibits 1 through 5 be marked for identification as pre-filed.
Hearing no objection, the motion is allowed. Mr. Harris, that of course includes the waiver of the confidentiality designation on page 16 of the testimony, I believe.
Yes, it does. Yes, it does,
Right.
Commissioner.
Right. Great. You may proceed.
Thank you. And Mr. Collins, did you also cause to be pre-filed in this docket on February 16th, 2021, 17 pages of rebuttal testimony and 6 exhibits?
Yes, I did.
And do you have any corrections or changes to that testimony?
Yes, I do. On page 15, line 21 of the testimony, I stated that the license for the facilities was approved in October 2016, but this should be December 2016.
Okay, thank you. And with that change, and if I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
Yes.
Commissioner Clodfelter, at this time, I move that the rebuttal testimony of John Collins be copied into the record as if given orally from the stand, and his exhibits 1 through 6 be marked for identification as pre-filed.
Unless there is an objection, hearing no objection, the motion is granted.
And Mr. Collins, do you have a summary of your direct and rebuttal testimony?
Yes.
Would you please present that to the commission?
Good morning, commissioners. My name is John R. Collins, and I am the former Executive Vice President and later President and Chief Executive Officer of Cube Yadkin Generation and its parent company, Cube Hydro. I provided pre-filed testimony on behalf of Cube in this matter. My direct and rebuttal testimony addresses several topics, including the negotiations which took place between Cube and Duke concerning a power purchase agreement for 3 qualifying facilities, which I shall refer to as QFs as we move forward. When Cube Yadkin established a legally enforceable obligation, which I'll refer to as LEO, and why the commission should waive the use of the notice of commitment form or NOC form to establish a LEO. The facilities at issue are 3 hydroelectric facilities located along the Yadkin River. The QFs. The facilities are commonly referred to as High Rock, placed in service in 1927, Tuckertown, placed in service in 1962, and Falls, placed in service in 1917. Prior to Cube's purchase of these facilities, they were owned by Alcoa Power Generating, Inc. A number of parties, including Cube, sought to purchase the QFs from Alcoa. Cube entered negotiations to purchase the facilities and began the due diligence process in early 2016. On June 30, 2016, Cube and Alcoa entered into a purchase agreement for the QFs. On July 25, 2016, Alcoa and Cube prepared and filed with the Federal Energy Regulatory Commission a request to transfer the license for the QFs from Alcoa to Cube. FERC approved the license transfer in December 2016. Pending the transfer and to assist with Cube's negotiations with Duke, Alcoa filed Form 556 certifying their QFs on September 28, 2016. Beginning in March 2016, Cube conducted meetings with Duke to determine how Duke would approach a long-term PPA. During these discussions, Duke was informed that Cube was pursuing the purchase of the QFs and wanted to enter into long-term PPAs with Duke. Duke was responsive to these entreaties. After an in-person meeting in or around June 2016, as well as email communications between Cube and Duke personnel, the negotiations began in earnest in August 2016. I initiated these conversations by reaching out to personnel at Duke and explaining that Cube planned to self-certify QFs, and I requested further discussions regarding a long-term PPA for the QFs. I also mentioned the possibility of expanding discussions to include a 4th facility, the Narrows facility, which is not a QF, because of the expanded benefits it could provide Duke and its ratepayers. I was referred to Michael Keene, who was my primary point of contact at Duke. Around September 16, 2016, I contacted Mr. Keene to further discuss Duke purchasing the output of the QFs. In a September 21st response letter, Mr. Keene acknowledged that Cube intended to self-certify 3 of the facilities as QFs and to sell the power from the QFs. However, he incorrectly stated, contrary to PURPA, that Duke would not have any obligation to purchase the power from the QFs. I responded in an October 11 letter stating the QFs were self-certified with FERC and that Cube wanted to meet to discuss the process for making sales from the projects to Duke pursuant to PURPA. My October 11th letter committed the output of the QFs such that October 11, 2016, at the latest, is the established date for a LEO. By letter dated October 14, 2016, Mr. Keene responded that Duke believed if the QFs were QFs, then Duke would be exempted from the purchase obligations. At no time during these discussions in August 16 through October 2016 did Mr. Keene or anyone at Duke mention the NOC form, nor do they mention any expected requirements for a CPCN. Strict application of the NOC form requirement would create a hardship for Cube and would be inconsistent with the public interest. There are several reasons the NOC form requirement should be waived. First, Cube proceeded reasonably and in good faith in not completing the NOC form. Duke's NOC form assumes that a facility must obtain a CPCN and ties the LEO date to the issuance of the CPCN. but the QS predate the CPCN requirement. In addition, the NOC form was not designed to accommodate operating generation facilities that predated the requirement for a CPCN. CUBE's counsel contacted the Commission's public staff, which indicated that CUBE should not expect Duke to make an issue of the facilities predating the CPCN requirement. And Duke never raised the issue in the parties' negotiations. The public staff did not indicate that CPCN was required. Second, Duke has essentially conceded that it would not have accepted the NOC form from CUBE had it submitted one. Duke argues that a NOC form may be submitted only by the current owner of a facility, even though such requirement is not imposed by the Commission, any proffered formal policy of Duke, or the NOC form itself. The NOC form requires submission by the seller, a requirement that CUBE could satisfy. Third, CUBE was far more than a prospective purchaser of the QFs, as Duke contends. CUBE's purchase of the QFs contractually obligated CUBE's purchase of the QFs contractually obligated to acquire the facilities once all necessary regulatory approvals were completed. Alcoa and CUBE initiated the license transfer in September 2016, which was approved by FERC in December 2016. Michael Keene's testimony that we did not negotiate with a non-owner of a QF under the circumstances presented by CUBE's acquisition rights is belied by the fact that he and others at Duke actively communicated with CUBE and participated in the PPA negotiation process. Further, Alcoa was in active cooperation with CUBE to facilitate CUBE's plan to sell the output of the QFs to Duke, which is evidenced by Alcoa certifying the QFs with FERC in response to Mr. Keene's September 21, 2016 letter to me indicating the facilities needed to be certified. Indeed, Alcoa fully supported CUBE reaching out to Duke and authorized us to do so. Fourth, CUBE, a waiver submitting the, Fourth, allowing CUBE a waiver from submitting the NOC form would not cause any harm or prejudice to any party and would be in the public's best interest. Under PURPA, CUBE is entitled to the avoided cost rates as of the date it established its LEO, which is at the latest October 11, 2016, after the Form 556 were filed, and CUBE through letters acknowledged that it was committing to sell power to Duke. The QFs would provide greater value to Duke than other QFs, such that there would be no harm to Duke's ratepayers and North Carolina citizens because the CUBE QFs are long-standing, reliable facilities that provide clean energy and ancillary services at lower or substantially the same cost to consumers as an expensive Duke gas facility self-build. Further, the CUBE QFs would also be helpful to Duke insofar as CUBE demonstrated a willingness to provide dispatch rights to Duke, which would enable the output of the facilities to be coordinated with Duke's own downriver hydroelectric facilities, and thereby providing Duke more generation control and support for the integration of intermittent resources on Duke's transmission and distribution systems. Fifth, refusing a waiver would reward Duke for its efforts to attempt to evade its PURPA obligations. Duke, well aware that of the planned changes to the avoided cost calculation methodologies in November 2016, had every incentive to delay the negotiations and to discourage CUBE from asserting its PURPA rights beyond November, which is what Duke did. For these reasons, waiver of the NOC form requirement is appropriate here. This concludes my summary of my direct and rebuttal testimony.
Thank you, Mr. Collins. Commissioner Clodfelter, Mr. Collins is now available for cross-examination.
All right, Ms. Fentress, you have the witness.
Thank you, Commissioner Clodfelter. Good morning, Mr. Collins. My name is Kendrick Fentress, and I'm attorney for Duke Energy. How are you today?
Good morning. I'm fine, thank you.
Great. Mr. Collins, we have heard already in this hearing a lot of dates thrown around and discussed, and I think what I'd like to do now is maybe walk through and see if we can't get a chronology going. If you could start by taking a look at Exhibit 6 of your pre-filed rebuttal testimony. Can you take a look at that? You can let me know there.
I have exhibit 6, I don't have exhibit 5. I apologize.
Oh,
Thought I had it printed out. I'm getting it.
sure, take your time. And just, if it's helpful, exhibit 6 that I have from you to your pre-filed rebuttal is Yadkin potential benefit for qualified facility sales to Duke Energy at avoided cost energy rate stated February 5th, 2016. Just to make sure we're on the same page.
Yes. Recall it.
I just have one question on this exhibit. I can ask if you agree, subject
Yeah,
to.
go ahead. Thank you.
Certainly. On page 2 of that exhibit, it is a PowerPoint exhibit that I believe Alcoa would give to potential purchasers of the Yadkin assets. And it says public utility company power purchases from qualified QFs. And it gives some facts about public utility power purchases from qualified QFs. And it says, if you will agree with me, subject to check, North Carolina law defines small power producer as entity, it says the owns or operates only QFs. I think that the probably should be a that. Would you agree with me, subject to check, that that's what that exhibit says?
Subject to check, I would agree.
Thank you. All right, now turning to your pre-filed direct testimony on page 7, 9 through 11. This was the subject of a correction you made, but I just want to walk through that a bit.
Okay.
You got there faster than I did. I apologize.
That I have.
Good.
I had the other one too. I don't know where it is.
I'm sorry myself. And with your correction, I do want to say on lines 9 through 11, it says Alcoa had previously certified each of these 3 QFs as qualifying facilities under PURPA. Are you there?
Yes, I am.
And then can you read the next line with your correction? I think that's where the correction was.
Well, I think my correction is for both of them is that they really certified them, as of September 28th, 2016. And then Cube Yadkin filed revised Form 56 with FERC, reflecting the change in ownership in March, I believe, of 2018.
And thank you, that is correct. And I would like to now turn to that Form 556 that has been marked, may I have marked for identification as Collins Cross Exhibit number 1. And Chairman Clodfelter and Commissioners, this is noted as attachment 2 to our cross-examination exhibits.
All right, it will be so marked as Collins Duke cross-examination exhibit 1.
And this is the, make sure I have the run too. Is that the Form 556 Falls?
Yes, that's precisely it.
I'm trying to bring it up. Thank you.
Okay.
Yes, I have it.
Great. And I think you've already agreed with me, but I'm going to ask this question for the record. If you would take a look at page 6 of this 556 form, where it says the facility name, can you read out the facility name?
I'm trying to mind. Mine are not numbered, unfortunately.
Oh, it is hard to
Oh, it's
see.
at the top. It's at the top. Okay. The facility name.
Excuse me, Mr. Collins, this is a court reporter. If you could speak towards your microphone, I could hear you a little bit better.
Okay, thank you. I apologize. I'm just trying to see the facility name.
I think you would agree with me, this is the Falls facility.
It is the Falls facility, yes.
Great. Great. And would you please turn to page 18, which at the top reads Certificate of Completeness, Accuracy, and Authority.
Yes. Yes, I'm there.
Great. And would you agree with me that the date at the bottom of the form is September 28th, 2016?
Yes, I do.
And turning back to page 5, where I think which says Form 556 at the top.
Yes.
You will agree with me that the applicant is Alcoa Power Generating, Inc.,
Yes, I do.
and it is not Cube Hydro or Cube Yatkin or any other entity.
No, it is not.
And would you agree with me, if you look further down on page 5, it looks like 1L paragraph, that the expected effective date for this filing is shown below as January 1st, 2017.
No, I do not agree with that. That is meant to be January 1st, 1917, when the plant went in service.
Okay, thank you. Would you agree that this form indicates that this facility has never been a QF before?
I agree. The form states that it had never filed for QF status before.
Thank you. And turning to page 7, would you agree that this form indicates on September 28th, 2016, and I'll let you get to page 7, I'm sorry, not mean to get ahead,
Yes.
that the facility operator is identified as Alcoa Power Generating, Inc.?
That is what the form says.
And do you see anywhere on this form, and you can take a look, where it mentions Cube Hydro or Cube Yatkin?
No, I do not. But that's because the form is certifying facility, not the owner.
And do you see any mention of an impending sale?
I do not. But again, just the form is referring to the facility and not the owner.
Understand. But it does have spaces where it indicates who is operating the facility. You would agree with me there?
It does.
And it has spaces where it indicates who the owner of the facility is. You would agree with me?
And it does do that as well. But
Okay.
again, the QF certification is for the facility, not the operator or the owner.
Understand. Mr. Collins, I can walk through the High Rock form, which is attachment 3, and the Tuckertown form, which is attachment 4. But my questions would be the same. Because of this way we're doing the hearing, I'm happy to do that, or I'm also happy to stipulate that the questions would be the same and the information would be the same. And I leave it to your attorney how he would like to proceed with that.
Thanks, Kendrick. I mean, I think we're fine. We're fine. Proceeding with the same questions and answers for High Rock and Tuckertown.
Certainly, certainly. So, Mr. Collins, if you could then look at what I would like marked for identification as Collins cross-examination exhibit number 2. And I'll let you take a look when you get there, or let me know.
I'm sorry, Ms. Fentress, which document do you want so marked?
I apologize. It is attachment number 3. And it is the High Rock facility FERC Form 556 filed by Alcoa Power Generating.
All right, that will be marked for identification as Collins, Duke cross-examination exhibit number 2.
And Ms. Fentress, this is Philip Harris. The one point I'd make is if you want to just introduce each one of the exhibits, and then we can just approach the question of whether we'd stipulate to the same answers as we had for falls. I think that would be the
That's a great idea. Happy to do it that way. Yes. So I will also add to this attachment number 4, and may I have that marked as Collins cross-examination exhibit number 3, and that is the Tuckertown facility FERC Form 556 filed by Alcoa Power Generating.
It will be so marked.
Thank you. Mr. Collins, do you have both of those in front of you?
Exhibit number 2 and exhibit number 4?
No, sir. It's exhibit number 2 and 3. It was attachment number 4 to what I sent. I apologize for the confusion.
Exhibit number 2 and number 4.
Yeah, to the extent it's helpful. This is Philip Harris again. These exhibits were originally classified as attachments, so it may be easier just to look for attachment 3 and attachment 4, which are now going to be designated as exhibits 2 and 3.
Yes, I have those in front of me.
Great, thank you. If you have them in front of you, will you turn please to page 6?
I have to do it one at a time if that's
Certainly.
Okay.
Certainly.
Page 6 on attachment, and this is okay. Okay, I am on page 6.
And you will agree that's the facility name shown there, Tuckertown.
I must have the wrong one.
If you have High Rock, I'll say High Rock.
I have High Rock.
Great. And then if you look in the same place for the other Form 556, you will agree that's Tuckertown.
I will agree to that.
Thank you. And I think I can get through this quickly. And you will also agree that the full name of the applicant for these QF status is Alcoa Power Generating, Inc.
I will agree with that as well.
For both of them. And you will turn to page 7. And at the bottom of page 7, it asks for the facility owner to be, for the facility operator to be identified. And will you agree that both of those facility operators are Alcoa Power Generating, Inc.?
I will agree with that.
Okay, great. And you will agree with me as well that the date that these were submitted is September 28th, 2016.
Yes.
Okay. And additionally, would you agree that this form indicates that the facility has never been, that these facilities have never been QFs before, have never been certified as QFs before?
I will agree that they had never been certified as QFs prior to that date.
And will you agree with me that neither of these forms mentions Cube Hydro or Cube Yadkin?
I will agree with that, but again, it's a certification of the facility, not the owner or the operator.
Understand. And you agree that the owner and operator shown on these forms is Alcoa?
At that time, that is correct.
And neither of these forms mention any impending sale?
No, they do not, because it's not a requirement of the form.
All right. Mr. Collins, Cube closed on the asset, on the purchase of the Yadkin asset, the Narrows facility, the High Rock facility, the Tuckertown facility, and the Falls facility on February 1st, 2017. Isn't that correct?
That is correct.
And this date is later than the date you initially provided to Mr. Keene as a proposed closing day or a potential closing day. Is that correct?
That is correct.
You had initially indicated that the closing would be November 1st, 2016. Is that?
I think I initially indicated it'd be somewhere around that time, but not a specific date.
Okay. Turning to your pre-filed direct testimony on page 4, lines 16 through 17.
Okay. I am there.
Okay. Will you agree with me that that reads the license was transferred? I'm sorry. if you could back up to line 14, I apologize. Alcoa and Cube prepared and filed with the Federal Energy Regulatory Commission a request to transfer the license for the facilities from Alcoa to Cube Hydro in September 2016. Is that correct?
That is correct.
Okay. And you have indicated the license was transferred by order of the FERC. And in January of 2017, was this one of your corrections as well?
That was one of my corrections. That should have been in December of 2017.
All right. Just a minute. And turning to page 15 of your pre-filed rebuttal.
Pre-filed rebuttal, okay.
Lines 19 through 21, you testify there that Cube Yadkin was contractually entitled to acquire the facilities once all the necessary FERC approvals, including a license transfer, which was approved in, and I believe you've corrected that, December of 2016. Is that correct?
That is correct.
Okay. Now, I would like to pull up attachment number 5, which, if I may have marked for identification as Collins Cross Exhibit number 4, and that is the FERC order approving transfer of license.
It will be so marked.
Thank you. Do you have that, Mr. Collins?
I do have that in front of me.
Okay.
Yes, I do. Just so I'm talking to my camera.
Okay. And just to clarify the record, can you tell me would you agree that this is the order approving license, transfer of license between Alcoa and Cube Yadkin?
Yes, I agree.
And can you tell me the date of that order?
The date of that order is December 13, 2016.
And can you look at page 6 of that order? And let me know when you were there.
I am there.
Great. If you could look at paragraph C, can you read out the first 1, 2, 3, 4 lines of paragraph C?
Approval of this transfer is a contingent upon transfer of title of the properties under license, transfer of all project files, including all dam safety related documents, and delivery of all licensed instruments to Cube Yadkin Generation LLC, which shall be subject to the terms and conditions of the license as though it were the original license.
So would you agree with me that even though this order had been issued in December of 2016, there were matters to be handled after issuance of the order by the terms of the order?
Yeah, I would, what I would tell you is that those are standard closing items that are required with the sale of any FERC regulated hydroelectric project.
Thank you. Would you now turn back to your testimony on page 7?
Is this my pre-filed testimony or my rebuttal testimony?
Your pre-filed direct testimony. Sorry about that.
Okay, no problem. Seven. Okay.
And to clarify again, I think this is one of the corrections where you said on September 28th, 2016, Cube Yadkin filed the revised forms. I believe you've turned that, you corrected that to say March 9th, 2018, showing you what has been marked. And I'm sorry, this would be attachment number 6. And I think with the permission of your counsel, I will try to do all 3 of these at the same time, as we did with the Alcoa FERC forms. 6 7 and 8, these attachments. These are the FERC forms filed by Cube Yadkin.
All right, Ms. Fentress, we'll mark item 6 on your list. That will be marked as Collins Duke cross-examination exhibit number 5. Item 7 on your exhibit list will be marked as Collins Duke cross-examination exhibit 6. And item 8 on your exhibit list will be marked as Collins Duke cross-examination exhibit number 7.
Thank you.
Got it.
Clodfelter. Do you have those exhibits in front of you, Mr. Collins?
I have exhibit number 6 in front of me. I can get 7 and 8 if we need to.
Let's start with 6 and see how we do. Would you agree with me, Mr. Collins, that this is a filing made at the North Carolina Utilities Commission on behalf of Cube Yadkin Generation?
We're talking about the 556.
Well, there is a letter on top of it from Van Ness Feldman, and it's dated March 9th, 2018.
I would agree that that's what the letter does, yes. It submits the 556 filing.
Thank you. And if I look strange, it is because Mr. Kaler is to be commended for his energy efficient office. The lights have gone out. I've not moved around. And you will agree that this letter says, begins with the line, pursuant to the Federal Energy Regulatory Commission's regulations, it cites a regulation, and it has the enclosed FERC form for Cube Yadkin Generation. Would you agree with me that that's what the letter says?
That is what the letter says.
It's a transmittal letter, basically. You agree with that?
That is what the letter is, yes.
Turning to page 5. No, I'm sorry. Turning to page 18.
Yes.
You would agree that this is dated 3/9/2018.
I would agree with that.
And would you agree that the other two Form 556s filed by Cube Yadkin reflect similar information, and they were filed at on or about March 9th, 2018?
Yes, I would agree with that.
Thank you. Now, Mr. Collins, I think we discussed with respect to the Form 556s that the assets in question here had not been used to make purpose sales to Duke in the past. Is that correct?
That is correct.
And in fact, Alcoa itself had indicated in its presentations to Cube and other potential buyers that the hydro facilities in questions had access to PJM, the world's largest wholesale market.
That's what their presentation stated.
And also access to MISO.
That's what their presentation stated.
And also access to SOCO.
And that is what their presentation stated. As part of the U.S. electric grid, they have access through transmission systems if you can get transmission to those markets.
And also the Cube Yadkin assets, that's their own balancing authority. Is that correct?
Cube Yadkin Transmission, Yadkin Transmission is a separate transmission and balancing authority, company and balancing authority, not the generation company.
Understand. Thank you. And do you know if they ever considered or ever did sell to Santee Cooper?
I do not know factually, but it is likely a possibility that they did through non-firm transmission.
And turning to pages 5 through 6 of your pre-file direct.
5 through 6, Mike. Okay.
Yes, sir. I'm at line 23 or 22, I should say. And can you read those starting with the word together?
Line 22.
Yes, sir.
Together, along with the Narrows facility, the 4 purchased facilities have a total generating capacity of approximately 220 megawatts, and they are expected to produce nearly 800,000 megawatt hours of clean, reliable electricity per year, enough to power approximately 72,000 homes with renewable energy. Downstream of these, is that all?
Yes, that's correct. Thank you. And then just to be clear, 800,000 megawatts of megawatt hours of clean, reliable energy includes the Narrows facility.
Yes, it does.
So the Narrows facility is not part of the claim before the commission today.
No, it is not.
So if the commission allowed Cube's waiver, that 800,000 megawatt hours would be less. Is that correct?
Yeah, it would probably be 50% or more or less than that.
Thank you. And since the Narrows facility is not a QF, selling to Duke, and I believe you mentioned this, from all 4 facilities was an option that Cube could pursue.
It was an option that we were considering pursuing, yes.
And do you know if Alcoa sold to PJM?
I am not aware personally whether they did at the time. So no, I'm not personally aware.
But do you know if Alcoa sold to DEC or DEP? Correct.
Yeah, I am aware that they have sold historically to DEP and DEC. Yes.
Thank you. Do you know any about SCANA? Do you know if they've sold to SCANA?
I do not know specifically if Alcoa had sold to them, but it would not surprise me if they had.
So as part of the discussions with Duke, Cube sought registration of all 4 facilities, including the Narrows facilities, as new renewable energy facilities at this commission on or about March 16th, 2017?
That is my understanding, yes.
And if the commission allowed these registrations, that would allow Cube to sell RECs along with the power generated by those assets to the companies. Is that correct?
That is correct.
So it would be a PPA that's bundled with the sale of RECs.
It could be a PPA bundled with the sale of RECs.
Has the commission approved these registrations?
Not to my knowledge.
If you turn to Exhibit 4 of your pre-filed rebuttal testimony,
Yes.
would you agree with me that that is an email from Eli Hobson to Christina Johnson and to you?
Yes.
And that the email indicates I had a phone call with Charlotte on this. Is that Charlotte Mitchell?
That would be Miss Mitchell, yes.
And she was acting as a representative of Cube at this time.
That is correct.
So you have indicated that this email says that the public staff told Cube that Cube should not expect Duke to make an issue out of the CPCN. Is that correct?
That is correct.
But you will agree with me that the public staff does seem to leave it open by adding Duke, that it would be a fairly easily rectified situation if Duke did make an issue out of the CPCN.
They may have mentioned that, but it may not be as easily reconciled with the requirements of establishing the LEO as exists today.
So you sought the public staff's counsel and they said, didn't expect Duke to make an issue out of the CPCN. Is that correct?
That is correct.
But then they added, according to this email, that if Duke did make an issue, it was a fairly easily rectified. It could be fairly easily rectified by an order of the commission granting an effective CPCN.
That is what the email says.
And so the public staff did not tell you that a CPCN was not required.
They did not. They also did not tell us that a CPCN was required.
They indicated that obtaining a CPCN was a fairly easily done process. Is that correct?
They did indicate that. However, the way that the existing process in North Carolina works, if we had pursued that, then the Leo date would not have been established under the knock form until we received that CPCN, which is different than the October 11th date that we established the Leo.
And you have an undated from you to Mr. Keene as Exhibit 2 to your pre-filed direct testimony. Can you take a look at that?
Yes.
Thank you.
The letter is undated. However, the email was dated, and it was dated I believe, October 11th.
The email we just referred to.
No, the email with this letter to Michael Keene.
Oh, I'm
was
sorry.
dated October 11th.
Understand. Now, in your testimony, Mr. Collins, in your direct testimony, you have indicated that you have expertise with PURPA QF self-certifications. Is that correct?
I have, yes.
And in this letter, this Exhibit 2, you cite PURPA. Is that correct?
I do.
And you cite several FERC regulations in the third paragraph. Is that correct?
I do.
And you are aware that state commissions establish LEO requirements under PURPA. Is that correct?
I understand they have the ability to do so, yes.
Now, nowhere in this letter do you ask Mr. Keene what the LEO requirements are. Is that correct?
I do not ask in this letter, no.
And you do, in fact, refer to a legally enforceable obligation at the second and last line of paragraph 3. Is that correct?
I do. And I just want to caveat one thing. While a state can enact it's how it wants to determine a LEO, it cannot enact such a requirement that is in conflict with the requirements of PURPA.
You are buying facilities in North Carolina at this time. Is that correct?
That is correct.
And so you would have been aware of North Carolina's avoided cost rules and establishing the requirements for a LEO. Is that correct?
We were aware of what it required to establish a LEO as existed at the time.
Are you saying that the North Carolina rules establishing a LEO are contrary to PURPA?
I'm saying that they do not, how they were designed, do not allow facilities such as the 3 QFs that we're talking about to legitimately establish a LEO because the knock form does not permit them to do so because it's not designed to reflect facilities that were placed in service prior to 1965.
So you were aware of the LEO requirements at the time you sent this letter?
We were aware.
North Carolina's LEO. And you agree that you did not ask if and when Cube owned the facilities, what the requirements would be, because you already knew them.
We knew what the process was in the state of North Carolina.
Do you know if Mr. Keene's an attorney?
I do not know whether he's an attorney or not.
Were you aware that the commission had also required as part of its PURPA proceedings for companies to put information about the knock form and establishing a LEO on their websites in February of 2016?
I was aware that that was it was in existence since February 2016, yes.
Okay, and turning to confidential, I'm sorry, it's not confidential. Turning to Exhibit 5 of your pre-filed rebuttal. Oh, I'm sorry, I don't Exhibit 5.
I don't either.
I apologize, it is it is confidential Exhibit 5 of your pre-filed rebuttal, based on what I have.
And which exhibit is that? I'm just trying to.
It's an invitation.
Okay.
And will you agree with me that this is an invitation sent to Ms. Bowman on June 22nd, 2017?
I believe it is. Yes. I'm trying to find it. I apologize.
Take your time.
And this is my
Rebuttal, pre-file rebuttal.
okay, that's why I don't find it. I'm looking at my other testimony. Okay, and which exhibit was it?
I have 5, yes.
Yes, I see it.
And you will agree with me that this is an invitation to Kendall Bowman.
Yes, it's an invitation to celebrate the 100 years of service of the Narrows facility.
And Ms. Bowman is a vice president at Duke Energy, is that correct?
Yes, that's my understanding.
And this invitation, I think we said this June 22nd, 2017. The party is for July 20th, 2017, is that correct?
That is correct.
And then up at the top, and it's very small print, will you agree with me that it says Cube Hydro Partners, which owns and operates the Yadkin Project hydro power plants near Baden, would like to invite you to a special celebration?
Yes, I see that language.
And that date is after the February 1st, 2017 date that the purchase of the assets closed?
Yes, it is.
So you were at that time the owners and operators of those facilities?
Yes, we were.
I have nothing further.
My space bar is not working and my cursor disappeared. Mr. Harris, do you have redirect?
Yeah, I do have a few questions, Commissioner Clodfelter. Mr. Collins, can we go back to that email? I believe it's Exhibit 6 to your rebuttal testimony, please.
Yes.
Well, let me make sure that I have the right one. It may be Exhibit 4. Let's see. Yes, it's Exhibit 4 to your rebuttal testimony.
Yes.
All right, are you there?
I am.
And can you read for me the last line from that email?
It says they did not think we needed to pursue independently unless necessary.
And that was the pursuit of the CPCN.
I believe it is, an order by the commission granting an effective CPCN. I believe that's what that sentence is referring to.
And the sentence says there's no reason they did not think it was needed to pursue independently unless necessary, right?
That is exactly what it says.
Okay, so at any time during the negotiations, did Duke raise the requirement of having a CPCN?
No, they did not.
When was the first time that you heard that Duke would require both the NOC form and the CPCN?
Not until after we filed our complaint with the commission, our initial complaint with the commission.
Okay. I think Ms. Fintress was discussing the FERC forms, but are the FERC form 556s, are all of the regulatory approvals that you may need to purchase a facility, et cetera, are those required prior to establishing a LEO?
No, to my knowledge, they're not required.
After submitting your pre-filed testimony and your testimony here today, do you want to change the date that Q believes a LEO was established with respect to the 3 facilities on the Yadkin?
Yeah, I believe the date that they established the LEO for the 3 facilities is October 11th, 2016.
And let me look at one exhibit. I believe it's, I'm not certain that we, quickly. If you would indulge me, Commissioner Clodfelter, I want to take a look at one exhibit, and I may have a question or two, or maybe not.
That's fine.
Okay, Mr. Collins, can you turn to what's been labeled as Duke Attachment 8? And Kendrick, I don't know what exhibit number that was. I think it's either 6 or 7.
I believe that if it's number 8 on the exhibit list, it was marked as Exhibit 7, cross-examination.
Exhibit 7. Thank you, Commissioner Clodfelter.
I have it, yes. I believe it's the.
And can you turn to the first official page, which is page 6 of the form?
Yes, I can. I am there.
So can you look at box 1L, please?
Yes, I see box 1L.
And what box is checked there?
Change to a previously certified facility to be effective on, and then says 2/1/17.
So the only change to this form was just the change from Alcoa to Cube Yadkin, right?
That is correct. It does not change that the facility is still a qualifying facility. It's just notifying of an ownership change.
Okay. All right. I think that's all I have with respect to a redirect, Commissioner Clodfelter.
All right, let's see if we have commissioners who have questions, and we'll begin with Commissioner Brown Bland.
Yes, Commissioner Clodfelter, I have a couple. Mr. Collins, good morning. And my first question has to do with, I think I'm going from your direct testimony, but there around page 9, according to my notes, let's see, you had the statement that, let me find it. It may not be exactly on page 9, but you have the statement in your testimony that following up of June 2016, following up after that, that Alcoa was aware and involved in and approved of the discussions with Duke. How was Alcoa involved in it? And
We had verbal conversations with Alcoa regarding this, and they had been supporting our efforts all along.
all right, well, I mean, and so that was between Cube and Alcoa. So was there any other participation that when you referenced Alcoa was involved in that that you were referencing by that phrase that they were involved in? Did they do more than discuss with you, or were they more actively involved?
Well, they were absolutely actively involved because they, at our request, following Michael Keene's letter in September 21st of 2016, they filed the Form 556 to certify the 3 facilities, self-certify the 3 facilities as QFs. So they were an active participant. You know, as part of an ongoing purchase agreement and trying to get to closing, you're actively participating in them on many fronts. And, you know, we didn't, you know, so we were actively discussing, you know, all activities with Alcoa during this time.
All right, and beginning at the top of your 9 in your direct about March 2016, you began to conduct meetings. Cube began to conduct meetings with Duke, and that those meetings involved the folks listed there who were folks from Cube Hydro and then folks from Duke. Did any Alcoa people participate
They did
or at
not
any time?
participate at that time, no.
And to your knowledge, did any people associated with Alcoa have discussions with Duke about what Cube was trying to do?
No, because at that time they assumed that we were the oncoming owners of the projects and they did not need to be involved in those discussions.
All right. So what's your position and testimony regarding how it was that Duke was aware that Cube was authorized to negotiate
Well,
at the point in time?
the simple answer to that is that Duke never asked us. We didn't think it was an issue. They never asked us for any support of that. The issue never came up. So if they had asked us, we would have worked with Alcoa to get them the appropriate documentation they were looking for.
Okay. And then on you indicate on August the 26th, I believe, that you had informed Duke that that Cube desired to enter into a long-term PPA. How was that communicated at that time, and how did you inform them?
Looking at my testimony, trying to find where that is in my testimony. I had basically there was telephone exchanges with Mr. Keene, and then there were emails between August 26th and September 6th, 2016.
So I'm looking at page 10 of your pre-file direct, lines 3 to 5. So you said after being referred to a Matt, is it Palasek or Palasek? And finally to Michael King, I, meaning you, informed them on August 26th that Cube Hydro desired to enter into a long-term PPA.
Correct.
Was that just in a verbal discussion with, and who did you direct that information to?
It was a verbal discussion with Michael Keene.
Okay, and Michael Keene alone at that point, not
Yeah.
Matt.
No, not Matt. Matt referred me to Michael Keene as the point of contact for our discussions.
Okay. Then on page 10, there, let me see, let me find it. So just for my clarification, on line, this paragraph that starts on line 6, page 10,
and this is my
pre-file direct.
Pre-file direct. I'm sorry, I'm looking at my rebuttal. I'm sorry.
Says on or about September 16th, I contacted Michael King to further discuss Duke's purchasing, and by responsive letter from Michael King dated September 21st. So it goes on to discuss things from that letter. Let's see. And then at the end of the paragraph, starting on line 14, you say in his September 16th letter. Is that the 16th letter was your letter to him, correct? Did you mean his September 23rd?
That probably should be that probably should be a September 21st letter.
21st. And so my question here is, if at this point in time Duke had indicated that it could not go further with Cube in terms of entering a PPA or negotiating a PPA because Cube was not the owner, what if that had been indicated to you at that point in time in September 2016, was there anything in accordance with the purchase agreement and what was happening between Cube and Alcoa? Was there anything that Cube could have done to have changed the ownership status?
We probably could not have changed the ownership status at that time, but we could have brought the Alcoa direct and, to the table to have more discussions. So if that had been an issue raised, we would have worked with Alcoa, and Alcoa would have been more than willing to work with us to continue to pursue discussions on a PPA. But that was never raised by Duke at any point in time.
All right, and that kind of led to the question I had. So, which was why Alcoa had not been involved or did not come, attempt to assist in entering the PPA.
Correct, because it was never raised as an issue.
Okay. But it was Alcoa. I think you already cleared up something that I had an earlier question about. It was Alcoa that made the self-certification with FERC before the ownership changed, correct?
That is correct, but I want to make sure everybody understands that you are self-certifying facilities as QFs. So that means that High Rock, Tuckertown, and Falls are then established as QF facilities. The owner or the operator is never a QF. They're just the owner or the operator. And the 556 in that form just says those facilities are QFs, which is a requirement under PURPA. It's not the requirement that the owner or the operator is a QF. It's the facility itself.
All right, and I think when you have discussed the NOC, the notice of commitment, you have made a distinction between the use of the word there, seller, and owner, and you believe that is important?
I absolutely do believe it's important. If the form wanted, or if the commission had wanted to know the owner there, then they would have asked for the owner separately than the seller. And in this case, Cube Yadkin Generation was going to be the seller, and we could move forward with committing the facilities. We could not, complete the NOC form because the way it's designed, but we were, the only two sections we could complete would have been sections 1 and 2, which Duke was already well aware of those matters.
All right, and so in your testimony, you indicated that Cube lacked the market access the sufficient market access that would have allowed Duke to take advantage of the, in other words, did Cube lack the market access to the wholesale markets that might have allowed Duke to be exempt from the requirement to purchase from the QF? Could you explain why you say you lacked?
Well, because we did not have a firm, long-term committed transmission into any of the markets that was being referenced in the cross-examination this morning. MISO, SOCO, we were just interconnected directly into the Duke Carolinas and the Duke Progress systems through an interconnection agreement with Cube Yadkin Transmission.
So that remained an open question. If Duke had sought an exemption, that would have been at least an open question that would have had to been addressed. Is that your position? The fact that Cube did not have have firm transmission.
That would have been one of our responses, but I think it's curious that Duke never pursued such an exemption. So I think that's curious by itself.
All right, one more. If Duke early on, say before the end of 2016, had negotiated the PPA and got ready to present the PPA to Cube, who would have been the parties to the agreement?
We would have assumed that Cube Yadkin Generation or either the individual facilities would have been the party to the agreement. However, we also would have looked to negotiate an assignment clause of that agreement in case the deal didn't close. So then Alcoa would have then taken that contract.
And so you believe is your position Cube would have executed that agreement and it would have been a valid agreement?
It would have been, and if we had to close that transaction prior to our ownership, we would ensure that Alcoa would have been either been a co-signatory of the agreement or would have agreed to an assignment of that agreement in case we hadn't closed. And it's our firm belief that Alcoa, who was cooperating with us, would love to have those contracts, those PPAs under those QFs under PPA contracts. Because in case that we didn't close the transaction, it would have reduced the revenue risk to them and made a future sale of those facilities much easier for them.
All right. I think that's all the questions I have at this time. Thank you.
Thank you, Commissioner.
All right, Commissioner Gray.
No questions at this time. Thank you.
All right, thank you. Commissioner Duffley?
Yes, I have a few questions. So if Cube had pursued a CPCN, would Cube have had to be the owner of the facilities to obtain that CPCN?
I'm not a lawyer, so I can't answer that question. But I do not believe they would have had to been. But I can't answer that question.
And then on cross-examination, you responded to Mrs. Fentress' question about when you were deciding whether to obtain a CPCN or not. Your answer was something along the lines of, well, if we had sought to obtain a CPCN, then we would not have been able to establish the LEO in October of 2016. Is that an accurate reflection of what you testified to?
It is, and I believe it's supported by the NOC form itself, which I believe is item 5 of the NOC form itself states that.
Okay, but what did you mean by if you had pursued it, the CPCN? When do you think you would have received the LEO if you had been required to obtain a CPCN?
Well, I don't know when. I don't know what the commission's time frame is for approving such applications, but the NOC form itself, if you had completed it, would say that the LEO date is the later of when you would have filed the NOC form or when you would have received the CPCN. And again, our position is these facilities predate any requirement for a CPCN and therefore are not required to have a CPCN.
Okay, thank you. If we could go to your direct testimony.
Sure.
So on page 8, you're discussing the Yadkin transmission system. Who owns and operates that system?
It is owned and operated today by Cube Yadkin Transmission.
And how much transmission is owned?
Well, the system probably has the ability to transmit above 300 megawatts of power through the system.
And are there other generators interconnected to this system other than the 4 hydro facilities?
No, but it is an open access transmission system, so anybody could apply for transmission access. But to date, the only transmission interconnection agreement with the system is between Cube Yadkin Generation and used to be Alcoa Generation and Alcoa Transmission, but Cube Yadkin Generation and Cube Yadkin Transmission.
And then on page, if you could turn to page 9, lines 12 through 14.
Yeah, I'm sorry, my pages are out of order. I got mixed up. I'm sorry, I'm trying to get it. this is the right
You,
book.
you probably
Yep.
don't need it.
I have it. I have it.
Okay, wonderful. You state Duke noted, that it wanted to have discussions concerning potential offtakes and buying power from the Cube QFs, as well as seek an understanding of how Cube would control and own the Cube QFs. Could you more fully explain what you mean when you say potential offtakes and buying power?
Oh, I think I mean, I believe I mean entering into power purchase agreements for the output of the facilities.
With Duke or with other buyers?
Well, in this case, it was directly with Duke. We were pursuing conversations to have long-term PPAs with Duke Carolinas or Duke Progress.
And were you pursuing with any other potential buyer?
We had no real conversations with anybody else at that point in time. Now, if opportunities that came up, we may have considered it, but there was no opportunities being seriously considered at that time.
Okay, thank you. And Ms. Fentress asked you about Alcoa and who Alcoa sold their output to. And as I understand your testimony, you stated that the only output sales that you are aware of were those with Duke, DEP, I assume.
I believe what I said was I'm not aware of specific sales to other parties. I am aware that they did sell to DEC and DEP.
Okay, thank you. So there have been arguments that if the commission were to allow a waiver of the NOC form for Cube, that the purpose of the form will be eroded. And I'd like to hear your response to that argument, please.
I'm actually in violent disagreement with that statement. The form, there are very few facilities that are QFs that predate 1965 when the CPCN requirement went in place that would ever fall under that form or the requirement for a CPCN. So to me, that's just a wild goose chase. And, I think the form should be redesigned to address facilities that predate the form. If you did it correctly, Section 3 of the form would have an other category that said no CPCN required because you predate the requirement. And then you would adjusted the other sections 4 and 5 so that your LEO date would have been established as the date you submitted the NOC form. But since the NOC form did not do that, there's no way we could fill out the NOC form and then just contradict the date we established a LEO on October 11th, 2016.
Thank you. So if you could turn to your, it was the confidential exhibit number 5.
In which testimony? I'm sorry.
In your direct testimony.
Okay. I think I have it. Is that the letter dated October 14?
It is from you to Regis. You've copied Christina. So it's your direct testimony.
I do not have that one in front of me for some reason.
You probably don't need it.
Okay.
In this letter, you state, given that all 4 plants are operated as a system, so including the Narrows facility, there may be interest by Duke in PPAs covering all 4 plants. And we've heard you testify that you were in discussions with Duke about long-term contracts for all 4 plants, as well as potential QF type PURPA contracts. So I just want to dig down into that. Are you suggesting that there may be operational, economic, and/or efficiency benefits in a PPA that covers all 4 facilities? And what are those benefits, both for Cube, and would there be different or similar benefits for Duke?
Yeah, I believe actually the real operational benefits to that, they would be on both sides, but primarily they accrue mostly to Duke and Duke's system. And here's why. The 3 QFs, if you look at the system, they start upriver with High Rock, Tuckertown, Narrows, which is the largest facility, and then Falls. And then the Falls facility, the water that leaves the Falls facility goes into the Tillery and Blewett facilities owned by Duke. So they use the same water. And today there is no dispatch coordination amongst that system. But the real benefits come from the fact that both the High Rock and the Narrows reservoirs hold significant water, and that water can be ponded. So if you take a look at High Rock, the High Rock reservoir above the facility can pond enough water to basically produce 185 megawatts for 182 hours with no new water coming into the system. Now that water obviously flows through Tuckertown and then flows through to the Narrows facility. The Narrows facility has a reservoir that can house up to about 82 hours of capacity with no new water coming in it, at 185 megawatts, which is, somewhat, the system can produce more than that, but on average, when you have a lot, that's a good number to use. So by having all 4 facilities, you can coordinate the reservoirs so that you are maximizing the economic benefit of the system. And that economic benefit accrues to Duke in a couple ways. Number one, it allows them better to coordinate the water that goes through their Tillery and Blewett systems. Number two, we were willing to discuss having dispatch rights to the whole system. So that would then enable Duke to use the system as a big battery that doesn't require electricity to recharge overnight, has water there, and it's clean. It's clean, green energy. There's no recycling of batteries that have to occur or anything like that. So and that would then help Duke as you continue to put more intermittent resources on the Duke system, such as solar, there's a lot of solar coming on the system today, that the ability to pond out water and use it when those intermittent resources are not producing where they think is extremely beneficial to the Duke system. And that's why we believe, and we believed at the time, that if you could get into a deal for all 4, it would be in the best interest. Now, if you only do 3, you still get the ability for that High Rock reservoir, but you can't maximize it the way you can if you had all 4 facilities.
And so I think you anticipated my next question. Are there any negative impacts or consequences in having 3 facilities under a PURPA PPA and the Narrows facility?
I don't think they're negative. They're not negative. You just don't get the full benefits, right? They're not negatives. The dispatch rights have to be a little bit different, right? There's things like that you would have to negotiate, but willing parties can come to the table and figure out how to make that work.
Okay, can you give an example to the commission where the company did not own the facility but was able to establish a LEO?
I cannot. I have not researched that, so I cannot give an example.
And could you explain
But I will posit a situation. You have a lot of new solar developers in North Carolina coming in. And in a lot of cases, those solar developers do not own the land that they plan on developing on. And so they file for a CPCN, and if they're small, and then a knock, but so they don't actually own the land. So technically, the land for a solar developer is their facility. They may not have in inventory yet the solar facilities. So technically, they may have an option to buy them. So technically, they potentially could get a LEO without having owned the land because they haven't exercised their option on that land yet.
Okay, thank you. And to the attorneys, I don't know if this is confidential or non-confidential information, but could you describe a bit, what are the differences between, you discuss a PURPA PPA and a non-PURPA PPA? What are the differences between those two types of contracts?
Well, I think Duke probably has a more standard PURPA PPA, but the reason I'm meaning it was just that the non-PURPA PPA was going to include it included all 4 facilities, and therefore it cannot be a PURPA PPA because Narrows would have been in it. So that's the real difference I was talking about. You will have some differences in terms like the dispatch rights and those type of things, but that's the real difference.
Right, but the real difference that you meant within your testimony
is basically the addition of the Narrows facility.
Thank you. And then if we could turn to your rebuttal testimony.
Okay. There's some pages there too. Okay.
And if you could turn to page 15.
Yeah, the page I don't have. Okay.
I don't think you need it.
Okay.
So on page 15 of your rebuttal testimony, you stated that Cube was contractually entitled to acquire the facilities once all necessary FERC approvals were obtained. And so I'm just attempting to understand your meaning of entitled. Did you mean that Alcoa could not back out of the deal? And that also, what about Cube? Were there provisions in the purchase agreement that would have allowed Cube to not purchase from Alcoa once the FERC approvals occurred?
The only thing that I recall, because it was pretty much an obligation to purchase, the only reason I recall in that agreement is that if there had been a material adverse effect, in other words, some material thing that would have happened to those Yadkin facilities prior to us closing. Now, those facilities have been operating more than 100 years, and there's never been a material adverse effect that happened to them. So to me, that is a standard purchase agreement term that is very rarely used unless there's a, let's say there was an earthquake and the whole system got damaged. That's where you would walk away. But, once we had absent that, once we had the final, and I'll use the word perfunctory regulatory approvals, we had an obligation to close.
Okay, and then if you could turn to your confidential exhibit number 6, rebuttal.
6. Okay. Getting there, sorry.
I need to get there as well. And it's on page 52 of the PDF.
52. Again, I don't have page numbers.
Well, I'll just read it to you.
Okay.
So it's a slide entitled Public Utility Company Power Purchases from Qualified Facilities. And it states, can you just explain these two terms to me, these two bullet points? It says QFs in service before 1979 paid utilities avoided cost of energy, and QFs not in service before 1979 paid utilities avoided cost of energy, comma, capacity. Can you explain those two statements?
Again, I lost the last one. The last one was before 1979, and they get energy and capacity.
Right. It says if the QF is in service before 79, they're paid utilities avoided cost of energy. And then it says for QFs not in service before 79, paid utilities avoided cost of energy, doesn't have the word capacity, but it has comma capacity. So what do those two bullet points mean?
I really cannot comment on those two bullet points because they came from Alcoa and I have not studied that. So I cannot comment on those.
Okay. And then if you could, you probably are going to have to find this slide. It's page 54 of the PDF. And it's a graph that's showing the Duke Energy avoided cost of energy rates paid to QS. And then it says smaller than 5 megawatts or higher than forecast Yadkin market prices for 2 years, 5 years, 10 years. Do you see that slide?
I need to find it. I'm having a hard time. I don't have that exact.
If I may, is this the page that's Bates numbered Duke 002226?
Correct.
So that may help you to find it.
I don't think so, but that's okay. And this is in my rebuttal testimony, correct?
Correct.
It would be helpful if somebody could email that to me.
Take it you're on it, Mr. Snowden.
I am.
I apologize. Okay. I have it. So what page is that? I'm sorry.
Page 54 of the PDF, or it's the Bates stamp number 002226.
I see it. I believe it's a chart that has 4 lines across and then has a dotted line going up to the right.
Correct.
And it says Duke Energy avoided cost of energy rates paid to QFs smaller than 5 megawatts are higher. Okay. Yes. Okay.
So the rates that are reflected in this chart are these energy only rates, or are they energy and capacity?
Be personally honest, Commissioner, I do not recall. This is a deck that was prepared by Alcoa as part of their sales process. So I don't recall exactly what comprises these rates.
Okay. I have nothing further. Thank you, Mr. Collins.
Thank you, Commissioner.
Okay, Commissioner Hughes.
No questions at this time.
Right, Commissioner McKissick, anything from you?
Just a few questions. Mr. Collins, when did you first become aware of the existence of a notice of commitment form that was required here in the state of North Carolina?
I don't recall an exact date, Commissioner, but I would say, late summer, 2016.
2016. Okay.
Yes.
And at that point in time, you were aware of it, but you did not believe it was necessary, required, because of the fact that the facilities here were predated what was determined to be the type of facilities that would require the filing of a notice of commitment form?
Well, I think that that's one of the reasons. I think another reason is it would have prejudiced our Leo date because the way the form is designed, as I've already spoken to.
I see. So at what point in time did you either seek some clarity or try to determine whether your assessment as to whether it needed to be filed or not? I mean, at what point do you kind of seek some clarity at whether you needed to comply? I mean, I'm just curious. I mean, I can understand the date issue, but at some point did you think that you might have needed to seek a waiver earlier, or feel that you needed to get clarity as to whether it was relevant to this particular transaction?
Well, we didn't think that we needed to do that. We thought that our position was pretty clear that the knock did not apply. And then even if we would have sought clarity of the knock, and which would technically require a CPCN, that we would not have established a Leo until after we got such an answer. And that answer would have been probably, we expected would have been later than October 11th, 2016.
Okay. And of course, I've heard you refer to that October 11th on several occasions. And that's the undated letter that you sent to Michael Keene. Is that correct?
It is undated, but it was accompanied with an email dated October 11th, 2016.
Okay. And what language per se in that letter that you can point to specifically that in your mind creates a legally enforceable obligation at that time?
So, number one, I would say the second paragraph establishes who the seller is, the information of the seller, and that the letter itself gives the contact information for the seller, which is Cube Hydro and me. And it also provides the details of the QFs, who the QFs are. The third paragraph notes that Duke must purchase the output from the QFs. And this, in our view, is an unmistakable commitment of the facilities output, selling the facilities output to Duke by the seller and the incoming owner of the facilities. And in our view also, this is particularly clear in light of the context of the correspondence, previous correspondence by Mr. Keene, and this being a response to Mr. Keene's assertion that Duke had no such obligation.
Okay. And of course, in response to that letter, I believe Mr. Keene sent you a letter that was dated October 14th of 16. Is that correct?
That is correct.
And did they express their thoughts and contentions as to whether you even owned the facilities at this time, and likewise whether they would be exempt under PURPA?
Well, they did say we do not own them, nor is it a qualifying facility. Well, let's dissect those two statements. Nowhere does it say anywhere that the knock form that you actually have to own the facilities. It says who the seller is. Number two, the statement is a qualified facility with respect to the active system is just a incorrect statement. The facilities are QFs. The owner and operator are not QFs. So High Rock, Tuckertown, and Falls had established QF status as of September 28, 2016. So that's just an incorrect statement.
Once those assertions were made and communicated, at any point in time, did Cube contemplate working with Alcoa to somehow overcome these perceived obstacles as you move forward by submitting some documentation that they might perhaps sign on as the true owner at this time, in which it stated or contemplated that any rights that might have existed to owner would be transferred to you as the sale was consummated?
We did not, and again, we didn't think that we had to. We thought that, we were in the position to negotiate, and if Duke had specifically raised that issue with us, that they wanted more proof from Alcoa, we would have worked with Alcoa and gotten that for them.
Okay. And when you closed on February 1st of the next year, I mean, at some point in time, did it occur to you that you needed to go back and kind of work through these issues now that you were the owner to overcome any obstacles that were identified as challenges that might be presented to you in terms of moving forward with the establishment of a PPA?
No, again, we didn't think the knock form applied. We didn't think that you had to be an owner. You just had to be a seller. And, there was no requirement for these facilities ever to have a CPCN. So we didn't think that was an avenue that we had to proceed down.
I see. Thank you. I don't have any further questions at this time.
Thank you, Commissioner.
Mr. Collins, my colleagues have asked most all of the questions that I would have asked you, but I got just a couple to clean up. With respect to the line of questions from Commissioner Brown-Bland relating to Alcoa, I just want to ask this question. Was there anything in the purchase agreement between Cube and Alcoa that specifically addressed Cube's authority to negotiate offtake agreements during the period prior to closing? Did the purchase agreements say anything about the subject at all?
No, it did not specifically address that matter.
Okay, thank you. I think you answered in response to Commissioner Duffley's question that Cube had become aware of the NOC form sometime in summer of 2016. The question I want to ask is this: Did Cube Yadkin give any consideration at that time to consulting with the public staff about the issues it had with the form?
We did not, because we consulted with the public staff related to the CPCN requirement. And since the CPCN requirement, they did not need to have it, right? The NOC form requires you to have it to establish a LEO date. So we did not specifically address that with the public staff at that time.
And in the consultations with the public staff about the CPCN issue, the NOC form never came up?
It did not, to my knowledge.
Okay. Well, I have to ask you one final question. It's kind of sort of the obvious question. Did Cube Yadkin ever give any consideration to filling out the NOC form, and when you got to the third item, simply write "not applicable," period, and then sending it to Duke?
We actually did give some consideration to that, but Duke's stance all along would be that they would not accept an incomplete NOC form, and that would have been an incomplete NOC form. So to us, we were in a catch-22. We were damned if you, damned if you don't, and so we took the path that we thought was the right way to go.
You referenced the stance Duke took all along was that they would not accept an incomplete NOC form. Where do I find that in writing? Is that written down somewhere?
I do not, I can't specifically point to it now, but I think we can go through and see, but I think there's stuff somewhere that basically says that you had to have the knock form, and I think even the exhibits they put in that, you know, on their website, that you have to submit a knock form, right? So, you know, I guess that was probably more our view at the time than a specific requirement. So, but that said, we could not then certify the 4, 5, or 6, because if we don't, NA, okay, what's the date of the Leo? You can't complete the form.
Did Mr. Keene or anyone else at Duke ever tell you that Duke would not accept an incomplete or non-complying knock form?
They did not directly, but I also say they never let us know that we needed to file a knock form.
Okay. Thank you, Mr. Collins. I appreciate your answering my questions. And that's all I have. So we'll go back and see if there are questions on commission's questions. And I'm going to ask Ms. Fentress and Mr. Harris, we're at noon. If we think we can get wrap up here by 12:30, we'll push on to 12:30, unless Kim Mitchell tells me she can't do it.
Yeah, this is Philip Harris. I see no issues why we can't be out of here by 12:30.
Okay, Ms. Fentress, work for you?
It does.
Okay.
Thank you.
And Kim Mitchell, you're the most important person.
I'm fine with that.
That's great. All right, then let's go back to questions on commission's questions.
Mr. Chairman, would you like for me to start?
Yes.
Thank you. Mr. Collins, I'm going to follow up on some questions that Chairman Clodfelter and Commissioner McKissick asked you. You had indicated that you felt like, or Cube felt like, it could not complete the knock form because it would somehow hinder its ability to establish a LEO due to the references to a CPCN on the knock form. Is that correct?
That is correct.
And I believe you did talk to the public staff, and you've testified to this, that they didn't think you needed to go get a CPCN unless Duke made an issue of it. Is that correct?
That is correct.
So they didn't rule out that you had to get a CPCN. Is that correct?
They didn't think we had to, but they didn't say no. They didn't say we didn't have to, I guess.
As one alternative to your due diligence in pursuing this transaction, could you have submitted the knock form to Duke and then asked the commission for a waiver of the CPCN requirement?
I guess that is a potential outcome, but if we had asked for that waiver, when would we have received it? And would Duke have made the argument that we didn't establish the LEO date until we received such waiver? And I believe, my belief is that you would have.
Did Cube review the commission's rules, I think specifically Rule R864, making this determination?
I'm not aware of that level of detail.
So that was not a part of your due diligence?
It wasn't a part of my personal due diligence. I'm not aware personally of that level of detail.
And you did have legal representation at the time?
We did have legal representation.
We also talked, you've also answered some questions about Alcoa and its participation or role in this. Alcoa has not, no one from Alcoa has submitted any pre-filed testimony in this proceeding, have they?
They have not.
And no one from Alcoa filed in support of the complaint that Cube initially filed at the commission, did they?
They did not.
And I understand that you indicated that if I followed your testimony correctly, that there was an assignment provision in the sales contract that if the sale fell through, Alcoa would be happy to take on those PPAs that you wanted to have with Duke. Is that correct?
What I stated is that we would have negotiated such a provision, is what I stated. There, we had never got into a direct contract negotiation, with that level of detail.
With Duke or with Alcoa? I just make sure.
With Duke.
You have no documentary evidence, however, to present in this proceeding that Alcoa would have been pleased with such an arrangement.
I do not have any documentary evidence, but it would have de-risked their assets and made them more saleable in the case we hadn't closed.
Alcoa was aware of your attempts to discuss with Duke the negotiation of potential PPAs. Is that correct?
That is correct.
We also talked about what a QF is, and I believe that you focused on an argument that says an owner is not a QF, but the facilities are QFs. Is that a correct representation?
That is correct.
Now, if you go back to I think the first question I asked you, I don't know if you found confidential exhibit 6. I think Commissioner Duffley was asking you about it.
And that's the one in my rebuttal testimony, or?
Yes, yes. I didn't want to make you have to pay for it, but I think I asked you, and I believe you agreed, that a small power producer under North Carolina law is a person or a corporation owning or operating an electric power production facility. Is that correct?
I believe that is correct.
And so a seller would not necessarily have to own a facility, but a seller would likely have to operate a facility. Is that not correct?
I'm not in a position to opine on that.
Kubiakin was not the operator of the facilities until after the close of the purchase with Alcoa. Is that correct?
That is correct. But
And that,
again, I will just state that the QF is the plant. And so, and upon a sale of that plant, that QF status transfers to a new owner.
but you are aware that North Carolina law defines a small power producer as the owner or operator of a qualified facility. You are aware of that.
Well, I would subject to check.
That was not part of your due diligence in purchasing these North Carolina facilities?
It wasn't part of my personal due diligence. I'm sure our legal team looked at that.
Okay. Kubiakin did eventually file a recertification petition. Is that correct?
We filed a notice of change of ownership and recertifying the facilities as of the date that they were placed in service, which is their original construction dates.
And that was pursuant to a FERC regulation, correct?
It's my understanding, yes.
And yes, one more question just about the closing. Did Cube transfer the funds to Alcoa for the purchase at the time of the closing?
Yes.
You didn't pay in advance?
No.
So I've heard you refer a few times to these sort of perfunctory regulatory rules and requirements. Is that a fair assessment?
I believe I said approvals, the FERC approvals is what I referred to as perfunctory. And as of October 11th, I believe we had all our FERC approvals and all our regulatory approvals other than one, which was the approval of the license transfer.
And I think you also spoke to, and I believe it was Commissioner Duffley, but I was going to ask you, Mr. Collins, does Cube have long-term firm transmission service into DEP?
We have an interconnection agreement with Cube Yadkin Transmission. I do not recall the term of that, what the term of that agreement is.
So you mentioned that you have non-firm sale of power into PJM. Is that answer the same for DEP?
We have, I believe, an interconnection agreement that allows you to get into DEP directly.
So I want to go back to the regulations that I was referring to and that you had talked about FERC approvals, and you would refer to them as perfunctory. Is it fair to say another way of looking at some of these regulatory approvals, either the LEO requirements or the FERC approvals for transfer of licenses, as something other than perfunctory, but regulations put in place to ensure fairness to the parties and protection of customers?
Well, I was not referring to the LEO, by the way. I was referring to the FERC license transfer approval. And the reason I say it's perfunctory is because they really judge the license transfer on two main issues. Do you have the experience to operate the system? And do you have the financial capabilities to assume the liabilities of operating and owning the system? And in the case of Cube, we met both those criteria. Therefore, in my view, that approval was perfunctory. It was going to happen. There was no question that it was going to happen.
It was contested, however, though, was it not? I believe the.
There was a gadfly contestant, yes.
One gadfly contestant?
Well, I don't know how many, I don't recall, but
If
the state of North Carolina.
timely motions, I'm reading from paragraph 3 of the order approving license, which is Collins cross-examination number 4. It says timely motions to intervene were filed on August 16th by Trading Ford Historic District Preservation Association, the North Carolina Wildlife Resources Commission. On August 30, 2016, timely motions were filed by, and if you disagree with me, please speak up, American Rivers, New Energy Capital Partners, Yadkin Riverkeeper. And on August 31st, 2015, timely motions or notices to intervene were filed by Central Park, North Carolina, the North Carolina Department of Environmental Quality, Stanley County, and the North Carolina Department of Justice. Will you accept that subject to check?
I will say that my gadfly reference was to the new energy intervention.
Thank you. Thank you. So again, I would say with all that interest in the approval of CUBE's ability to operate the facilities, would you agree that these perfunctory regulations that you've referred to are intended to protect, again, the rights of the parties and the consumers of the power?
Well, I think they're intended to ensure that the new owner and operator of the facilities has the experience and the financial capability to own and operate, which in my view, CUBE easily satisfied, regardless of the interventions.
And it easily satisfied it according to the FERC on December 13th, 2016, and then which was contingent upon closing. Is that correct?
That is correct.
And that closing was February 1st, 2017. Is that correct?
That is correct.
Thank you. I don't have anything else to ask on the commission's questions.
Thank you.
Okay, Mr. Harris.
Thank you, Commissioner Clodfelter. Mr. Collins, Ms. Fentress mentioned that there was a lot of interest in the transfer of the license, and do you think that interest would exist if CUBE Yadkin had filed for a CPCN?
I believe it probably would have. There probably would have been interventions in that as well. I think people ought to remember there was ongoing litigation regarding ownership of the riverbed by the state of North Carolina at the time CUBE was purchasing the asset.
So then would you think any CPCN process would be longer, shorter, or about the average time if CUBE did have to proceed and pursue a CPCN?
Well, I think at the time, if we had pursued it, it probably would have been longer because I'm assuming based on the level of intervention in the license application, we would have had some similar intervention in the CPCN requirement.
Okay. Let's go to that. I'll actually bring up that order that Kendrick referenced. And it should be attachment 5, which will likely be exhibit 4.
Attachment 5. Yeah, I have it.
Okay, and can you go to page 4, please?
Yes.
Okay, and can you just read that paragraph to yourself and tell me what's your impression of what FERC thought of the motions to intervene of New Energy?
Well, they thought that all the motions were not relevant to the transfer proceeding.
Okay. And from your impression, what were the two things that were relevant to the proceedings?
Whether we had the experience to operate the facilities and the system, and whether we had the financial capability to assume the ownership responsibilities and liabilities.
And if we go to paragraph 9, can you read that second sentence of paragraph 9 for us, please?
Moreover, a license transfer is ministerial action, does not involve any significant changes in the license, and does not provide an opportunity to reopen the licensing proceeding. We find no basis for reopening the relicensing proceeding.
You know, Commissioner Duffley had a few questions that she asked you that I'd like to delve into a bit. First thing, is it your understanding that Duke devised its own NOC form?
That is my understanding.
Okay. So then, if that's true, then it's fair to say that that this controversy basically arises from the fact that when Duke designed its form, it didn't contemplate getting NOC forms from facilities like the Cube QFs that predated the CPCN statute.
I would agree with that statement.
Okay. You were also
object, and I'm sorry. I was trying to. I believe Mr.
State your
Harris.
objection.
Certainly, I believe Mr. Harris's question states a fact that's not in evidence about Duke designing the NOC form. I basis for that question.
Mr. Harris, your response?
Yeah, I mean, it's the NOC form is designed by Duke. The very form that we're looking at is a form that's been that Duke submitted, and in fact, I believe there is an exhibit that was attached. You know, Defendant's Exhibit Attachment 4 that details the NOC form and the LEO establishment and the requirement of a LEO establishment. So, I mean, I don't know how that can't be in issue here when it's a NOC form that Duke argues now had to be filled out.
I believe sorry.
Mr. Harris, restate your question. I want to hear the pending question again.
Okay. So the first question was, is it your understanding that Duke devised its own NOC form?
Ms. Fentress, I'll allow him to ask the question and get an answer. And if you think that whatever assumption may be made there is incorrect, you have witnesses who can address the matter.
Thank you, Commissioner Clotfelter.
All right, so let me ask you an additional question. Commissioner Duffley asked you whether you could cite an example of Cube establishing a LEO before it owned a facility. Do you recall that?
Yes.
And you pointed out that developers of new solar projects can establish LEOs in North Carolina when they don't own the land they're developing on, right?
I use that as an example of a potential scenario. Yes.
Okay, and in fact, in that scenario, you know, the developer might not even own any of the physical equipment at the time that they establish a LEO, correct?
I believe that would be correct in that example. Yes.
Okay, so in essence, what you're pointing out is that in North Carolina, a developer can establish a LEO without actually owning any facility.
I believe they can.
Okay. And I don't think I have any further questions. Thank you, Mr. Collins.
Thank you.
Okay, Mr. Collins, thank you. Let's see what motions we have relative to exhibits.
Thank you, Commissioner Clotfelter. I'd simply like to, this is Philip Harris, by the way. I'd like to move into evidence our exhibits as marked and the testimony and everything else that we have put into the record.
Previously admitted the testimony, and we'll take that as a motion to move into evidence all the pre-filed exhibits to both the direct testimony and the rebuttal testimony marked as they were designated. And again, Mr. Harris, just to confirm for the record, the confidentiality designations on those exhibits have been waived, correct?
Yes, yes, that is correct, Commissioner Clodfelter.
Great. Any objection?
No objection.
All right. Motion is granted then.
And
Ms. Huntress?
we would like to, Duke Energy would like to move in to the record its cross-examination exhibits for Mr. Collins.
And those would be, as I recall, 1 through 7.
Yes, sir.
Great.
Yes.
And again, to the extent there were any confidentiality designations on those have been waived as well. Great.
Yes.
Any objection to the motion? Hearing none?
Objection.
Motion is allowed. All right, Mr. Snowden and Mr. Harris, what's next?
That is the close of our presentation of evidence, and I don't believe we have any further witnesses.
Okay, this would then be a good point, I think, to break for our lunch. And so let's suspend now, and we'll go into recess until 1:30. During the recess, please put your cameras on mute, your microphones on mute, and your cameras turned off. We'll be back at 1:30.
Thank you.
Mr. Harris, you still have your video on.
Just wanted to be the last man standing.
Fair enough.
Hey, John, this is Linda Garrett, just checking in.
Hey, Linda, audio and video sound good. You're good to go.
Great, thank you.
Sure, no problem.
Uh-huh.
How you doing?
Good afternoon, guys.
Good afternoon.
Everybody.
Okay, I think I can see, if not everybody's face, I can see everybody's name on my screen, I think. Linda, are you ready?
I'm ready, sir. Thank you.
Okay, that's great. All right, Ms. Fentress, I believe the case is yours now.
Thank you, Mr. Chairman. Bob Kaler. I'll be
All right.
working with these witnesses.
You guys are doing this switch hitting today, and I don't know the batting order. So, Mr.
That's
Taylor,
okay. So we would call our panel of witnesses Mike Keene and Glenn Snyder.
Okay, Mr. Snyder, I see you, and Mr. Keene's box is there, but his video is not on. There he is. I got him. Okay, gentlemen, will each of you raise your right hands? And unless there's some objection, we're going to do both, swear them both together. Do you and each one of you solemnly and sincerely affirm that the testimony you're about to give in this matter shall be the truth, whole truth, and nothing but the truth?
I do. I do.
All right, we got yeses from both. Mr. Taylor.
Thank you, Mr. Chairman. Mr. Keene, would you state your name and address for the record, please?
It's Michael Keene, 299 First Avenue North, St. Petersburg, Florida, 33703.
And you are employed by Duke Energy in what capacity?
I am a business development manager.
In preparation for this hearing, did you prepare pre-filed testimony consisting of 18 pages?
Yes.
Do you have any additions or corrections to that testimony?
I do not.
And you had 4 exhibits, I believe. Is that correct?
Yes.
And do you have any additions or changes to those exhibits?
No, sir.
So I'll go ahead, if it's okay, Mr. Chair, and let Mr. Keene give his summary, then I'll go to Mrs. Snyder.
That's fine.
Mr. Keene, I believe you prepared a summary of your direct testimony. Is that correct?
Yes, sir.
Would you proceed to give that summary to the commission and the parties?
Yes, sir. Good afternoon. The purpose of my direct testimony is to discuss the company's position in this case and respond to the testimony of Cube Yadkin's witness, John R. Collins. The company's acted in good faith to negotiate with Cube Yadkin in the interest of our customers and consistent with the commission's purpose policies and orders. Put simply, Cube Yadkin demanded and still demands to be paid prices for its capacity and energy that are inconsistent with the commission's policies and far in excess of what is just and reasonable for our customers to pay. I was assigned commercial responsibility for this project in August of 2016 after Cube Yadkin reached out to one of our executives, Regis Repco, to let him know that the Cube Yadkin intended to purchase 4 hydroelectric facilities along the Yadkin River, High Rock, Tuckerton, Falls, and Narrows, known as the facilities, from Alcoa Power Generation Incorporated. Typically, I would not discuss matters of this type with anyone other than the owner of the facilities because Duke does not want to provide information that might impact whether assets are ultimately purchased. On September 16, 2016, I had a conversation with Mr. Collins, which I followed up with a letter on September 21st, 2016, providing Duke's position on purchasing the output of the facilities. I noted that Alcoa owned the facilities, and I advised that Duke did not have any need for energy and capacity at that time. But if need arose in the future, Duke would likely issue a request for proposals or an RFP, and Yadkin could submit a bid. I further informed them that to the extent that Yadkin had approached Duke under PURPA, Duke would likely have no obligation to purchase the energy or capacity from the facilities that may be certified as QFs. On October 11, 2016, I received an undated letter from Mr. Collins in response to my September 21st, 2016 letter. In the undated letter, Mr. Collins indicated that Alcoa had certified the 3 smaller facilities as QFs and that Yadkin anticipate closing before the end of 2016. The letter also recommended meeting to discuss the process for making sales from these projects to Duke pursuant to PURPA, noting that Duke had not petitioned to be relieved of the mandatory obligation under PURPA to purchase output from the QFs. It should be noted that while Mr. Collins projected closing the purchase of the facilities on November 1st, 2016, the transaction was not completed until February 1st, 2017. Yadkin never offered an explanation on what caused the delay. I did not begin negotiations with Yadkin in the fall of 2016 because Yadkin did not own the facilities in question. And the first step in this process for the owner to submit a notice of commitment form. Company witness Snyder will provide details about Commission's requirements for the developer owner of a facility to establish a legally enforceable obligation, or LEO, in North Carolina. Typically, once the company receives a notice of commitment form, we calculate the appropriate avoided cost rates in effect at that time and lock in those rates for the duration of a power purchase agreement, or PPA. Yadkin has not, to this day, submitted a notice of commitment form. While Yadkin contends that part of the NOC form did not apply to them, it is unreasonable to conclude that a sophisticated company like Yadkin and an experienced employee like Mr. Collins, with access to legal experience, would have reached the default position of not submitting anything. The companies require the NOC firm from all potential PURPA suppliers and cannot complete the required analysis until we receive this form. After Yadkin closed on the purchase in February of 27, Duke negotiated in good faith and provided firm proposals to Yadkin on 2 occasions. On August 10th, 2017, Duke proposed a 2-year energy-only transaction with energy pricing based on a detailed analysis of the energy market at the time and offered to purchase the full output, 200 megawatts, from Yadkin, including the non-PURPA facility, Narrows. Yadkin rejected this offer. On September 25th, 2017, Duke proposed to purchase the output from all 3 QFs for a total of 108 megawatts for a 5-year term, with pricing based on DEC's avoided costs. $39 a megawatt hour on peak, $32 a megawatt off peak, with an average price of $34 a megawatt hour, using the regulatory methodology in place at that time. Yadkin rejected this offer as well. Yadkin also made 2 proposals to Duke. Duke rejected both offers because the pricing was significantly above Duke's avoided costs and exceeded current market prices. Also, the term was not consistent with the limits contained in North Carolina House Bill 589, and Duke was granted no dispatch rights or environmental attributes. In 2018, DEP issued an RFP to solicit capacity and energy to meet its future capacity needs. Yadkin was invited to participate and did submit a proposal. DEP executed 5 PPAs to secure approximately 1,800 megawatts of capacity and energy. However, Yadkin's proposal was not accepted because it was not competitive. Subsequently, both DEP and DEC executed PURPA as available agreements with Yadkin in April and May of 2019, respectively. In response to Mr. Collins' statements about Alcoa's approval and authorization of PPA negotiations prior to Cube Yadkin's purchase of the facilities, I respectfully disagree. Even if Alcoa might have approved negotiations, Alcoa never contacted Duke about purpose sales to the companies. And even if Cube Yadkin were authorized to negotiate on behalf of Alcoa, it could not have made any commitment to sell output from the Alcoa-owned assets. Furthermore, Duke did not draw out the negotiations with Cube Yadkin. A detailed review of the timeline clearly shows that Duke was responsive and that any long pauses were caused by Cube Yadkin, which basically disappeared for the 5 months during the critical time, October 2016 through March of 2017. I'm not aware of what caused the delay in Cube Yadkin's purchase of the facilities or the financial details of the purchases. However, Cube Yadkin's unrealistic and outdated demands for excessive pricing did not help move the process along. This concludes a summary of my pre-filed direct testimony.
Thank you, Mr. King. Mr. Snyder, would you state your name and address for the record, please?
Yes, sir. My name is Glenn Snyder. I'm employed at 526 South Church Street, Charlotte, North Carolina, 28202.
And what is your position with Duke Energy?
I am Director of Integrated Resource Planning and Analytics for the Carolinas Utilities.
And I believe you've testified before this commission on many occasions before, is that correct?
Yes, I have. It's good to see commissioners again, albeit in virtual format.
So, Mr. Snyder, did you prepare and cause to be pre-filed on your behalf direct testimony consisting of 10 pages?
Yes, I did.
Do you have any additions or corrections to that testimony?
I do not.
If I were to ask you the same questions today, would the answers be the same?
Yes, they would.
And do you have a summary of your pre-filed testimony?
I do.
Would you proceed to give that to the commission at this time?
Yes. The purpose of my direct testimony is to respond to the contention of Cube Yadkin's witness, John R. Collins, that Cube Yadkin is entitled to a waiver of the commission's requirements to establish a legally enforceable obligation, or LEO. My testimony focuses on the development of the commission's LEO requirements and how those requirements are significant in this case and important for the efficient administration of the LEO process in future cases. First, I explain what a LEO is and how it works. Under the Public Utility Regulatory Policy Act of 1978, or PURPA, a qualifying facility, or QF, has the unconditional right to choose whether to sell its power as available or pursuant to a LEO at a forecasted avoided cost rate determined at the QF's option, either at the time of delivery or at the time the obligation is incurred. Regulations of the Federal Energy Regulatory Commission, or the FERC, set forth in 18 CFR 292.304 subsection D2 are intended to protect the QF's rights to sell power to the utility under PURPA, where the QF and the utility cannot agree to the form, terms, or rates of purchase power agreement, or PPA. Put simply, FERC's LEO concept provides that the QF and the utility can either negotiate and enter into a PPA, or if the utility refuses to enter into a contract, the QF can seek the assistance of the state regulatory authority to bind the utility to purchase power from the QF by establishing a non-contractual but still binding LEO prior to the execution of a PPA. If a QF establishes a LEO in North Carolina, there is a bifurcated approach to determining the applicable avoided cost rates. Generally, smaller QFs may qualify for the standard rate, which is established by the Commission every 2 years. Larger QFs that do not qualify for the standard rates have their avoided cost rates calculated on a regular basis to reflect economic and regulatory conditions that exist at the time those calculations are made. As a general rule, a QF in North Carolina chooses the avoided cost rate in effect at the time the LEO is established. Next, I describe how the Commission established LEO requirements. Prior to 2015, the commission's policy provided that a LEO is established when a QF has 1, obtained a certificate of public convenience and necessity, CPCN, or filed a report of proposed construction if applicable, and 2, indicated to the relevant North Carolina utility that it is seeking to commit itself to sell the output of that facility. The second prong was too vague to be implemented fairly for all QFs, and there was not enough guidance on what it meant for the QF to commit itself to sell its output. Complaints and requests for arbitration resulted in costly litigation and unnecessarily utilization of resources by the commission and the parties, and ultimately led the commission to establish new LEO requirements effective January 16th, 2016, which include 3 prongs. 1, self-certification as a QF with the FERC. 2, making a commitment to sell the facility's output to a utility pursuant to PURPA via the use of approved notice of commitment form. And 3, receipt of a public convenience and necessity for construction of the facility. Finally, I discussed how the LEO requirements impact the company's customers. In the final analysis, the company's customers pay the avoided cost rates that the companies pay to the QFs. The LEO helps align the avoided cost rates that our customers ultimately pay to the QFs with the company's current avoided costs. Allowing QFs to establish LEOs that do not reflect current avoided costs places the risk and burden of overpayment on our customers. This risk is exacerbated if the QF has the latitude to retrospectively select a LEO date that provides the QF the highest possible revenues at the expense of our customers. The Commission has attempted to mitigate this risk through the LEO requirements. This concludes the summary of my pre-filed rebuttal testimony.
Mr. Chairman, at this time I would move the direct testimony of Keene and Mr. Snyder into open exhibits be marked as certified.
Unless there is objection. And hearing no objection, the motion is granted.
And the panel is available for cross-examination.
All right, thank you, Mr. Kaler. Mr. Kaler, your audio was choppy a little bit there. You might just want to, next time you speak, check it.
Will do. Thank you.
Okay. All right. Who's going to be cross-examining the panel?
I will, Commissioner Clodfelter.
Very good. Thank you. You may proceed.
Thank you. And good afternoon. Good afternoon, gentlemen. Thank you for appearing today. I'll do my best to designate who I'm asking the question of. I could start with you, Mr. Keene. On pages 13 and 14 of your pre-filed testimony, and again in your summary, you stated that Duke only accepts NOC forms from a facilities owner. Is that correct?
That's correct.
And so if Cube had submitted a NOC form in 2016, has it been fair to say that Duke would not have treated it as a valid submission?
That's true.
And in fact, you testify on page 13 of your pre-filed testimony that in your view, the real reason Cube could not complete the NOC form was that it was not the owner at the time it wished to establish a LEO. Is that true?
That's correct.
And if we could, let's look at what has been marked as or what we submitted as attachment 1 to our potential cross-examination list, and I'll ask that it be marked for identification purposes as Exhibit 1.
All right. This will be marked for identification as cross-examination, Duke panel cross-examination Exhibit 1. Let's just call them all Duke panel and do them sequentially rather than worry about whether they're with Mr. Snyder or Mr. Keene. All right?
Yes, thank you, sir.
All right, it'll be marked for identification as panel cross-examination Exhibit number 1.
Okay. Would you let me know when you have access to that, Mr. Keene?
Is this the NOC form?
Yes, sir.
Yes, I do have access to that.
Okay. And so I take it then that you do recognize what it is?
I do recognize it, yes.
Okay. And is it Duke's NOC form?
It is Duke's NOC form.
Okay.
I will tell you that I think Mr. Snyder was planning to answer questions as it relates to the NOC form.
Okay, and in interest of time, whoever has the answer, I'm fine with that. So I'll ask Mr. Snyder if you don't mind. Do you have access to the exhibit?
Yes, I do.
Okay, thank you. And do you recognize it?
I do.
Okay, and is it in fact Duke's NOC form?
It is the NOC form that Duke has adopted per the commission's order. And I believe it was Dominion that developed this NOC form, and we adopted it per the commission order.
Okay, so
it's the NOC form we use at Duke per the direction of the commission.
Right, does that mean that if I understood right, someone at Dominion perhaps drafted it and it was submitted for approval by the commission? Is that right?
Yes, if I remember how this NOC form was adopted, the commission adopted the Dominion NOC form in the sub 140 order, and we accepted that and used that internally to follow the directives of establishing a notice of commitment.
Okay, and does this form use the word owner?
I believe it uses the word seller.
And if you look at the signatory block, that's page 3 of 3. All it asks is that it says, quote, "The undersigned is duly authorized to execute this notice of commitment for the seller." Is that correct?
That's what it says.
Okay. And I don't believe it was called as an exhibit, but if you could pull up what was attachment 9 to Duke's potential cross-examination exhibits, and Attorney Clodfelter, I'll ask that it be marked for identification purposes as Duke panel exhibit number 2.
It will be so marked.
Sure.
You look a little panicked there. Let me know when you have access to it, Mr. Snyder.
I'm challenged virtually here. My exhibit 9 that I'm looking at was a letter from Christina Johnson to Thea Jamil, so I'm assuming I might be looking at the wrong exhibit 9.
This was Duke's cross-examination exhibit, and you may not need it if I can represent this as Duke's compliance filing with the NOC form and copies of its websites.
Okay.
Do you know if those use the term owner?
I believe they use the word seller.
Okay. Thank you. Now the CUBE facilities were constructed before the enactment of the CPCN. Is that correct?
Yes, they were.
And if we go back and look at the NOC form, which is the first exhibit we had, sorry to bounce around, that'll stop. But if we look at the first exhibit in section 5 of the NOC form, it requires the submitting party to agree that the LEO date is either the date of submission, if there's a CPCN or a report of proposed construction, or the date that the facility possesses a CPCN or report of construction, if it's after the submission, whichever is later. Is that correct?
Yes.
So if CUBE did not have a CPCN, how should it have completed this form?
I think it could have written not applicable, CPCN is implicit given the age of the units.
I missed that last part, I'm sorry.
I think it could have just put NA and said CPCN is implicit given the age of the units.
And if I can ask under section 5, do you know if they had written that, what would be the LEO date for the facility?
I think it would have still had to be when you owned the facility, because a seller has to be an owner. I mean, we can mince words around seller and owner, but you have to own something before you have the right to sell it. And I think seller is intended implicitly to mean owner in this case.
I just want to make sure I understand the answer, though. It's that it would have taken effect when Cube owned the facility?
I believe that would have been our contention. Or had Alcoa submitted it, it would have been when they submitted it, depending on whoever owned it, since the assets have changed hands.
Well, and I'll ask this of either you or Mr. Keene, whomever the right person is to answer it. Why not then tell Cube you need to get Alcoa to submit this form?
The form was posted, and I think we've already heard testimony that your witness knew of this well in advance of talking to Mr. Keene. I think he testified to the fact that he was aware of this form prior to any discussion with you.
Right, but if it was Duke's position that it needed to receive the form from Alcoa, why not so indicate?
Because Alcoa never expressed an interest. Alcoa had owned these assets for decades upon decades and had had ample opportunity long before the sale of the asset to attempt to sell these as a QF, but elected to sell these at the highest available price to whatever buyer was buying for that day.
So let me ask you this. Do you believe that Cube was required to obtain a CPCN from the commission to complete the NOC form?
I think had the Cube submitted the NOC form with an NA and said these facilities predated the CPCN and have met the intent of this section of the NOC form, the commission could have taken that and done as it saw appropriate with it. And I'm not sure we would have had issue with it.
Okay. Now, if you, your testimony, you speak about the risks of allowing a facility to establish a LEO without the NOC form. Do you recall that?
I do.
And do you know how many facilities there are that predate the CPCN requirement? In other words, do you have a sense of how many facilities that risk applies to?
I do not know of all the QFs we have, how many that would apply to. I do remember 10 years ago being in a very similar arbitration to this with a couple of QFs who there was a large debate over when the LEO was established. And they may have predated because those facilities were existing for a long time, but I don't know exactly how many we have that predated.
When you say they may have, do you recall specifically?
I don't. They were I think the commission noted it, were some of the cogeneration facilities that we had served, that had served us as QFs leading up to 2011 when that EBCOR proceeding took place.
Thank you. Mr. Keene, on page 11 of your pre-thought testimony, you state that it's your responsibility to assure that prior to beginning extensive discussions, any party seeking to provide capacity or energy under PURPA actually owns the facilities and has established a LEO. Is that right? I think you may be on mute, sir.
Sorry about that. It's my responsibility to make sure that they have a knock form in place and that they own the facility, yes. Typically, the knock form is the beginning of the analysis. So what we do is, once we get the knock form, I get the analytical people together, the regulatory attorney, say, hey, we got the knock form. And that's basically the start of us of putting the PPA and calculating the avoided costs. So from my perspective on as a commercial representative for these types of transactions, the knock form is really sort of the start of the whole process for me.
I understand. And in terms of assuring ownership, what's the source of that responsibility? Is it a Duke internal policy?
I don't know that we have a policy to make sure we're talking to the owner of someone trying to sell the output. I mean, I think one of the key things I do from a commercial perspective is, especially in the process that Cube had, is to deal with anyone that's a prospective buyer on an arm's length basis. We don't want to say or do anything that could impact the purchase or sale of a major acquisition like that. If I were to say something or give them some type of information that was inaccurate or could change over time, it could impact that transaction. So we're very careful that before, when we get this a lot, we have a lot of power plants. We have 60 hydro PPAs just in the Carolinas itself. And these assets are smaller and they tend to change hands. So we have to keep track of who owns them, who's maybe going to buy them, who's, prospective buy it, who's looking at. There's a lot of people out there trying to learn information from us before they bid on a plant. So we got to be careful of that we don't have that somehow impact those transactions in a negative way. So typically, from my perspective, it seems somewhat obvious that if someone's going to sell the output of a power plant, that they own it.
I understand. I'm just trying to understand, if you say it's your responsibility, why do you say it's your responsibility? Is it?
Why it's my responsibility to make sure that people selling me something own it? I don't understand the question.
I just mean, where does it come from? Is it, or do you believe you're doing it in furtherance of a commission order? Do you believe you're doing it pursuant to?
I think it's a good business practice to make sure that the people you're talking to own something if they're trying to sell it to you. I mean, we get a lot of people who may own a plant someday, and that doesn't work for us. You have to actually own it before we're going to deal with you.
Okay. It's fair to say you've negotiated PURPA PPAs with many, haven't you?
I don't know what you mean by many.
How many, if you had to estimate, how many times have you negotiated PURPA PPAs?
Maybe 25 of them or so, maybe more.
And what steps do you?
Probably more than that.
I'm sorry, I didn't mean to cut you off.
No, that's okay. Probably more than that, but.
Okay. Yeah. What steps do you normally take to ensure the party you're negotiating with is the actual owner?
I've got a contract administration individual that will contact the contact information, and he does the paperwork to make sure that. He also handles any change of ownership, change in control. He also handles the knock form. To give you an example, of those 60 hydro PPAs we currently have in the Carolinas, 4 of those expired on Sunday, and a couple of months ago, those 4 hydros submitted their knock forms, and the new PPA started on Monday. We have 4 more that will be starting on March 15th. So I work with the contract administrator to make sure that we have the knock form, that they've established the LEO, that, and then I meet with the analysts and we start putting the PPAs together based on, is it a DEC, is it DEP, is it South Carolina, is it North Carolina? What rules are in place in that time, make sure we get them the correct avoided cost and a PPA.
And when the company receives a knock form from a QF seeking to contract under the standard offer, does the company do anything to ensure the form is filled out by the actual owner?
I don't know the answer. I don't know what the contract guy does as it relates to that. I do know that he will reach out to them if there are problems with it. The corporate structure of some facilities can get kind of complicated, so getting the right owners on the paperwork sometimes complicated, but we need to have the right owner because we're going to be sending them invoices for sending them money, so we got to make sure we have the right owners, but the contract administration group handles that. I don't really get that involved. I do know that if the knock form is if there's an issue with it, they'll contact the owner and make sure that it gets fixed, and then once it's complete, we'll put it in a file, and then we'll begin essentially the commercial process of calculating the avoided costs and putting a PPA together.
And when it comes to interconnection matters, does Duke deal with companies who aren't the actual owners of projects when it comes to interconnection agreements?
I don't know much about interconnection agreements. We have folks that handle that. We have one group that does the transmission interconnections. We have another group that does the distribution interconnections. That's handled by that group. I don't get involved in that. I do make sure that we have interconnection agreements in place before we do a PPA with someone if they're directly connected to us. In your situation, Cube Hydro, they're in their own BA, so the interconnection agreements between, I guess, Cube Yadkin Transmission and your own power plants, but so I don't know that the interconnection agreements would impact this transaction at all.
Yeah, I'll just ask Mr. Snyder if he knows the answer to that question. When dealing with an interconnection agreement, does Duke require that it deal with the actual owner, or does it just have to be someone authorized by the actual owner?
I have the same response as Mr. King. I'm not the department that processes interconnection requests.
Okay. Thank you very much. All right, Mr. Keene, if we could, let's look at, let's go back to my actual list here. Let's look at the attachment number 6, which I'll ask to be marked for identification purposes as Duke panel cross-examination exhibit number 2.
Mr. Dowdy, you had earlier wanted to mark the knock form as number 2. Are you withdrawing that, or are you withdrawing that earlier marking, or you want to make this one number 3?
I apologize for my bad counting, Commissioner Clodfelter. I'd like to make it number 3.
All right, it will be so marked.
Did you want me to pull up a document, Mr. Dowdy?
Yes, attachment 6.
Okay, give me a second.
Yes, sir.
Is this a August 2016 email?
Yes, sir. August 23rd, 2016 email.
Yeah, I've got that up.
It's a multi-page exhibit actually, but let's start with the one at the top. You indicated earlier that Mr. Collins reached out to someone at Duke, Regis Repco. Is that correct?
Yes.
Okay. And is this the email you were referring to there?
Yes.
Okay. If you look at the first paragraph, the third sentence, it says, I'll just read it for everyone's benefit. As we discussed in our meeting, we plan of registering 3 of the assets, High Rock, Tuckertown, and Falls, as qualifying facilities, and would like to have further discussions with Duke regarding longer-term QF contracts for these facilities.
I see that.
Doesn't that indicate to you that at a minimum, Cube plans to sell the output of the 3 facilities that could be certified as QFs pursuant to QF contracts?
When I read this, it does sound to me like they're trying, when I read this email, it does sound like they're not only trying to sell those 3, but also the Narrows one to us at some point in the future.
Yeah, that they would, So it's your understanding they would like to do both. They would like to sell all four.
Mhm. Yes, yes,
But my question was that at a minimum, they wanted to sell from the three.
yes, it looks like that in the future, they would like to sell either the three or all four.
Okay, and then if you'll, you'll flip to the next page of Exhibit 3. It's it appears that if you go all the way to the back of that exhibit, it's Duke 001722 is the Bates number. Is this
Yeah,
the
I'm there.
email making you the point of contact, the commercial contact for a potential PPA?
Yes, I was assigned commercial contact on August 25th, 2016. Yes.
Okay. And then moving forward, Mr. Collins followed up with you about a meeting.
Where is that? I'm sorry.
The next email at the bottom of 1721. You flip forward a page, I'm sorry.
Oh, okay, yeah, I see it. Sure.
Yeah, the email chain starts at the back.
Yeah, I see it. Sure.
Okay, so, and, you know, fair to say he sends you a very similar email to what he sent Mr. Repko.
Okay.
And then above that, it looks like there's some internal discussion at Duke about whether or not you've gotten back to him. Do you see that?
Let's see here. I got introduced to John, it looks like on August 26, 16. Is that right? And then on August 30th, Matt asked me, left him a voicemail, have an internal meeting with the analyst tomorrow. May not have an outtake meetings on purpose. Yeah, I do see that. Are you talking about the August 30, 2016 email at 1:36 p.m.?
Yeah, let's look at that one.
Okay.
There's a second sentence there that you read quickly. Let me read it and see if you agree this is what it says.
Sure.
We may not have an obligation to take their units under PURPA if they have access to an organized market.
Right.
And it says just getting started on the initial review.
Sure. Right.
And I guess my question is, this doesn't reference anything about a lack of ownership, does it?
No.
And it doesn't reference the lack of a NOC form?
No.
Or the lack of a CPCN?
No.
Okay. 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 Now, let's look at attachment number 3 to our cross-examination list.
Right. Let me get to that, please.
Yeah. And I'll ask that it be marked for identification purposes as number 4. Commissioner
It will
Cloudfelter.
be marked as Duke panel cross-examination exhibit number 4.
Thank you.
Is this the memo dated September 21st, 2016?
Yes, sir.
Okay, I've got it up.
All right. And do you recognize this letter?
Say that one more time.
Do you recognize this letter?
I do.
And is it your response to Mr. Collins?
Yes.
It also indicates it follows a discussion you had with Mr. Collins, correct?
Yeah, we had a conversation on September 16th, and this memo basically tried to summarize that conversation.
Okay. And apologize, just one moment. All right, so the letter references Alcoa being the current owner, is that correct?
Yes, I was basically reminding Mr. Collins, based on the conversation at September 16th, that again, they didn't own the facility yet, and it would be, I didn't use this word, but it would be inappropriate for us to deal with them and not the owner of the facility on any potential sales. But basically, we're reminding them that they didn't own it yet.
You said you did or didn't use those words, that it would be inappropriate to deal
I don't think I used the word inappropriate, no, but it would have been inappropriate to deal with, someone who didn't own the facility.
But the letter doesn't actually state that, does it?
No. Let me read it. It's been a while since.
Oh yeah, please. I'm not trying to rush you.
That's good. Yep. I don't use the word inappropriate in there. No, it just basically reminds them that Alcoa is the owner of that facility.
Well, the letter doesn't state that Duke won't have discussions with Cube because Alcoa is the current owner, does it?
No, I don't think it does. No.
And it doesn't say anything about a knock form, does it?
No.
All right. At the end of paragraph 2, you reference Cube's plans to certify the facilities as QFs. Do you see that?
Yes, I do.
And you indicate that if Cube does, Duke would likely have no obligation to purchase the facilities outright. Is that correct?
That's correct.
And at the time you wrote that, had Duke obtained an exemption from any PERPA purchase obligations?
No, I just really wanted to let Mr. Collins know that we at least had some internal discussion that the organized market exception could apply. We felt that it was, a way to demonstrate good faith and say, hey, look, you need to go look at this because there is an organized market exception in PERPA. These assets are frequently sold. The output is sold into organized markets. That's a fact. And so that it's a possibility that this may apply. We would have had to go to FERC to get approval for this exemption, and we've never done that. We really just want to give them a heads up to do their due diligence on this issue. But we never actually went to FERC and did that. At this stage in the game, before they own the plant, we just want to make sure they did all their own homework themselves.
Okay. See one thing. Your letter references that the facilities were not yet certified as QFs. Is that correct? Say it notes it.
Yes.
And were you present for the testimony this morning?
I was.
Okay. And do you recall the testimony that on September 28, 2016, Alcoa self-certified Falls, Tuckertown, and High Rock as QFs?
Yes, I expect that this letter probably had something to do with that. Yes.
Yeah.
Within a week to the day after this letter was issued, then they were certified.
And
we weren't surprised. We weren't surprised by that.
Okay.
Should have been done probably a long time ago. We don't really know why Alcoa never did it, but yeah, Alcoa certified them on September 28th. I have that information.
Okay. Was that not an indication to you that Alcoa was supportive of Cube's efforts to have a discussion with you about PPAs? Or
Not at
PPAs?
all. Absolutely not at all. No.
Why do you say that?
Well, because I think at that stage of the game, Cube's just a prospective buyer. they're not the owner of the asset. Maybe Alcoa decided they want to do it. You know, I mean, maybe they decided they wanted to be QF. Maybe they were concerned that the transaction was not going to happen. Who knows? I don't know why, but that just because I figured Alcoa went and certified the things as QF because Cube Hydro probably went back to them after they got our letter on 21st and said, hey, these things have never been self-certified. And so they went and did it, but it didn't mean to me that Alcoa wanted to commit to sell these power plants to either DEC or DEP under a long-term agreement. I wouldn't have drawn that analogy at all.
Understand.
Okay.
So, did you ask anyone why Alcoa did it?
I did not. You know, and we mention it in a letter, and a week later they do it. We figure they're just probably doing that at the request of Cube to get ready, just in case they actually own the thing in the future if the deal actually closes.
You know, you refer to Cube as a prospective purchaser, correct?
That's correct.
But you spoke about the diligence that you did in some of these transactions or had someone do. Were you aware at the time that Cube was under a contract to purchase the facilities?
I can't remember when I became aware that they had a contract under purchase. I know that, but as I'm sure you do, as I'm sure as you know, that getting from a purchase and sale agreement to a closing can be a challenging process. There's a lot of steps that have to be taken, especially with assets where FERC is involved like this. There's no guarantee that a purchase and sale agreement leads to ownership. And again, I cannot deal with people that may own a plant someday.
Well, did you ask where they were in the process?
I can't recall. I would suspect that Mr. Collins probably kept me in the loop. I think he originally told me they thought they'd be done November 1st, and my answer was great. Let's talk then.
Did you hear Mr. Collins testify this morning that all that remained as of that time were routine regulatory approvals?
I heard him testify. I can't remember him using the routine regulatory approval language, but I don't know what a routine regulatory approval is, but I've been involved in some purchase and sales of hydros before, and there tends to be a lot of things that have to get done from the PSA to closing. And until that happens, the owner is Alcoa. If Alcoa had told us they wanted to sell output from those plants under PURPA, we would have talked to them. They never did that.
All right. Let's look at what is our attachment number 4, and I'll ask that it be marked for identification purposes as a Duke panel cross-examination exhibit number 5.
It will be so marked.
This is the October 11th, 2016 letter?
Yes.
Well, yeah, the undated letter, but the email was dated October. Yeah, I'm there. I got it.
No, I don't. I grabbed the wrong document. I'm sorry. All right. So, for me, a pre-file testimony. You do not dispute, do you, that you received this on October 11th?
I do not dispute that, no.
And so this is a letter from Mr. Collins to you. Is that right?
Yes.
And is he responding to your September 21st letter?
Yes.
And I want you to look at the first sentence of paragraph 2.
Yeah, I see that. Mm-hmm.
Okay. Says that Cube Hydro has agreed to acquire the Adkin projects from Alcoa.
Right.
Is that correct?
Is what correct?
Well, did I correctly read it?
Yes.
And after reading that sentence, were you aware that Cube had contracted for the purchase of the facilities?
Yes. I was aware that they agreed to acquire the Adkin projects from Alcoa.
And if you read the second sentence, it says the acquisition is anticipated to occur before the end of 2016.
Right.
Did that indicate to you that it was being finalized?
Well, my takeaway on that when I read that sentence is, well, when you own it, come and talk to us, because I have to calculate your avoided cost based on when you meet the commission requirements, and you have to submit the NOC, you have to establish a LEO, and you can't do that on a prospective date. In other words, it's a perfect example of why we require the NOC form, to tell you the truth, because they're saying that they're going to be, previously it was November 1st, now it's the end of the year, and then it'd actually be in February of the following year. So that's kind of the issue, is that I don't know when to start the analysis because the dates kept moving. So from our perspective, it's when they own the plant and submit the NOC form is the date we calculate it from. So that sentence to me is like, okay, well, thanks, John, for the update, but when you own the plant, let's talk and let's start negotiating.
Well, and I'll ask either you or Mr. Snyder, are you aware of FERC ever stating that a LEO cannot be established by a party who is contracted to purchase a QF but hasn't purchased it yet?
That sounds like a legal question. I can't answer that. I don't know if Glenn can or not.
I'm not aware of a case that's been before FERC where a prospective buyer has tried to establish a LEO. I think it would be interesting if there were multiple prospective buyers. Maybe they could all try and establish LEOs.
And are you aware of any commission order denying a LEO by a party that was in a contract to purchase but hadn't purchased it yet from this commission?
I'm not aware of anyone attempting to establish a LEO without owning. Therefore, I'm not aware of them denying.
Well, and here's what I'm trying to get at. So when we say that I believe this is your phrase, Mr. Keene, come talk to me when you own it. Is that just Duke's interpretation? I mean, where is that coming from?
Well, I think it's, again, this is Keene. I think it's a good business practice. I mean, I don't have any documents from Alcoa or anyone else that gives Cube the right to sell the output of their power plant. It's not Cube Hydro's power plant. How can they sell the output from it? It's Alcoa's power plant. They're the ones I'm going to go talk to, or they can come and talk to me. How do I even calculate avoided cost when I don't know when they're going to own it? Like I said, it was November of 16, then it was December of 16, ended up being February of 17. What number am I supposed to use? I need some type of starting point for the, a fixed point for the analysis. I mean, the NOC form protects both parties. It's not there to protect one or the other. It protects both parties. It's an unambiguous start to the analysis. And I can't do it on a floating potential acquisition. I don't understand why that's different. I don't know why that's a point of contention. I mean, if Alcoa wanted to sell us the output of the plant, we would have been happy to talk to them about that.
So if I understand the answer to my question, it's that you consider it a best business practice. Is that right?
I consider it to be a good business practice to talk to the owner of the plant when someone's selling the output of it. Well, talk to the owner of an asset when someone's trying to either sell the asset or sell the output from that asset. That the owner should be involved in those conversations, yes.
So after reading turning back to the exhibit, after reading the third sentence of paragraph 2, were you aware that the 3 facilities had been self-certified as QFs?
Yes, you previously asked that question. I think it was September 28, 2016.
I apologize.
That's okay.
Now look at paragraph 4.
Okay.
And I'll give you a moment to look at it.
Yes.
After reading that paragraph, were you aware that Cube didn't agree with your contention that Duke was not obligated to purchase the output of the 3 facilities?
I did, yes.
Gotcha. All right, thank you.
Mhm.
Now, let's look at cross-examination attachment number 5.
Okay, give me a second to find that.
While you're looking up, I will say, I'll ask that for identification purposes, it be marked as Duke panel cross-examination exhibit number 6.
It will be so marked.
Hi, Mr. Dowdy. I have the October 14th, 2016 memo up here.
Okay. And this is a letter from you to John Collins 3 days later, correct?
Yes.
I'll look at paragraph 2 about the 6th line down. It says that
Paragraph 2.
I'm sorry, yeah, second paragraph.
Okay, go ahead.
The big paragraph. 6th line down, it says you inform us that Cube Hydro seeks to purchase the Yadkin system from Alcoa.
Right, yes.
But again, at the time, you were aware that Cube was under contract to purchase the facility.
I think what I said was, I'm not sure at what point I became clear to me that they had a purchase agreement in place. I just know that they didn't own it at that time.
Oh, yeah, maybe I can save us some time. It didn't matter to you what stage they were at pre-formal ownership. Is that a fair statement?
That's correct. Yeah, until they own the plant. I mean, now, yeah, I mean, there's a possibility that it never went to closing. And until it went to closing, until it happened, until they were the owners, until they were handed the keys, you know, I felt it would have been inappropriate to deal with the non-owner of the facility. If the owner of the facility wanted to sell the output, we've been happy to sit down with them and talk to them about it, but not someone who might own the plant at some date uncertain in the future.
Yeah, and so a couple of questions there. What would you have required from Alcoa in order to move forward with Cube? Is there some kind of authorization you could have been given that would have assuaged your concerns?
I mean, I think if Alcoa expressed an interest in either a PERPA or a non-PERPA transaction, I would have brought in legal counsel, and depending on whether it was PERPA or non-PERPA, get back to Alcoa and talk to them about, you know, kind of which path they want, what they were looking for. I mean, we would, you know, we would have no problem entering a PPA from a hydro like this. If they had expressed an interest in that, we would have been happy to work it out. They wanted to do the PERPA transaction. They would have had to meet the legal obligations that Glenn spoke of a little while ago. If it was a non-PERPA deal, we would talk to them about, you know, what we see the market at and the type of pricing that we would be able to justify to our leadership and to the commission. They just never did that.
And you again reference in this letter, don't you, your position that Duke would be exempt from purchasing from Cube under PERPA?
We do. And again, I wanted to make sure Mr. Collins knew we were having those conversations internally. We hadn't made a decision whether to follow up on that, but we, you know, there is an organized market exception. They were selling into organized market, had been too for a very long time. But at the same point, we never made the decision to move forward with that. And, you know, as you can tell, once, you know, when you get to the timeline, you'll see that once Cube actually did own the plants in February 2017, we did provide offers. Once the NDA was in place and the letter agreement, we did provide offers in summer of 17.
And So if I understand, the reason you included the language is that you wanted Cube to be able to do its diligence and, make sure it had, done whatever diligence it needed to do.
Yeah,
right?
I wanted Mr. Collins to know that, we had conversations internally. No decision had been made on which path we'd like to take as it relates to that. We wanted to make sure they knew it and did their work. I was brought into it because as a commercial guy, it was my responsibility to try to determine if those assets had been sold into organized markets.
Mm-hmm. And the letter doesn't reference the need to submit a knock form.
No, it does not.
And it doesn't request that Alcoa submit any forms to Duke.
Nope, it's not.
And it doesn't ask any questions about status.
I apologize. I didn't hear that last statement.
It doesn't ask any questions about the status of the transaction, does it?
No, I mean, it had been, to us now, it was pretty obvious it was taking longer than they expected.
Okay. Just one moment. All right, would you look with me at our cross-examination exhibit number 9?
Is this the email from Christina Johnson to Thaddeus?
Yes, sir.
Okay.
And if you would, just tell me, do you have an understanding of who Christina Johnson is?
She was the well-connected CEO at Cube Hydro during a lot of this time. I don't remember when she left. During summer 16, she was there. I can't recall when she left the company.
I understand. And who is Dia Jamil?
There's one of our executives. I don't remember his role at the time, but he was one of the executives at Duke Energy.
I understand. And this email attaches a press release, does it not?
Yes, it does.
Okay. It's dated July 11, 2016.
Yes.
And does that indicate that there's an agreement to purchase the Yadkin facilities?
I will agree that it does. I haven't read it.
Fair to say that, at least someone at Duke was aware.
Yeah, I think so. I mean, we don't make business decisions on press releases, though. Again, it goes back to what we've talked about all along, and that is until the deal closes, until they're the owner, they can't make a commitment to sell those assets or sell the output from those assets. So it doesn't really change anything from my perspective until Cube Hydro owned it. There wasn't really much to talk about.
But you did have a number of discussions with Cube in 2016, is that correct?
Well, yes, and the reason for that is that Cube Hydro managed I Squared Capital, which is I think at that time was the owner of Cube Hydro, had been working with our executives on another large transaction, and so they knew each other and had relations that were well connected. So there was a lot of interaction at the executive level. I Squared is, as you know, a large private equity company, $15 billion. I believe they owned Cube until maybe October of 2019 when they sold it to Ontario Hydro. So I think they were the owners at the time, and I think they knew a lot of the executives at Duke.
Okay, and that, in your view, is what facilitated the discussions?
Well, I think normally what would happen is if there's an asset on the market and someone's a prospective owner at some point, prospective buyer of that asset, they would reach out to us and we would say, hey, look, if you close the deal, if you get everything done you need to do, you own the facility, come and talk to us, and then we'll talk to you. If not, we'll talk to whoever the current owner is. And usually that's just one or two phone calls and that's the end of it. Here, because of the connections between I Squared Capital and the Duke executives, there was a lot of interaction at that level about this transaction. And so there was a lot of effort put in with letters and emails and phone calls and meetings to try to keep Cube Hydro in the loop on what we were doing, what was going on. When you buy the plant, let us know. We'll put something in, we'll start negotiations then. So there was a lot of effort put in. We treated them, in a lot of ways more favorably to other people. And we, tried to be responsive to them. But the bottom line, until they owned the power plant, there wasn't a lot of things we could do with them at that point. It would be, it just wouldn't be fair to Alcoa to be talking to someone else about buying the output of their power plant.
Well, how many meetings would you say you had with Cube in 2016?
Well, maybe meetings is I'd have to go back and look. Maybe meetings is the right term, but I would say there was a lot of calls. I don't have a list of all the meetings that were held. I'm sure the Cube Hydro folks do, but there was a lot of internal meetings to discuss. Hey, Thea got called, or someone's reaching out to Lynn Good. They want to know what the status is, or our state president David Fountain, Regis Ripka. They were getting contacted, Kendall Bowman, by different Cube people and Cube representatives pretty frequently. So there was a lot of emails and meetings, and typically before someone owns the power plant, it's just like, okay, call me when you close on the deal, and we'll put something in place. And in this situation, there was a lot more pre-work. I wouldn't call it negotiations, but there was a lot of discussions before they owned it, which was not typical.
Well, and that's what I'm trying to understand.
Okay.
And I'm sorry I'm not putting it well. I'm going to try again. Why all the discussions if the answer is we can't really talk to you until you own the facility?
These discussions were initiated by Cube Hydro. You should ask them. They're the ones that constantly contacted our executives, and they were trying to be responsive. They had other relationships, other business opportunities, and I think really, if anything, I know we demonstrated a good faith on our part to try to keep you in the loop of what's going on. When you own it, talk to us, we'll put something in place. You had really access to our leaders that a lot of folks I've dealt with over the years didn't have. So I would say that you guys initiated all this. Our answer was pretty much the same the whole time. Talk to us when you own the power plant and we'll negotiate with you. If not, have Alcoa call us. I didn't actually say that, but I mean, if Alcoa ever calls, we would negotiate with them.
Well, you said you didn't actually say that. Why didn't you say that? Have Alcoa call?
It seemed, I don't know, it seemed obvious to me that the owner of a power plant should be the people we're talking about selling the output of the plant. I don't know that I had to explain that, especially as someone with Mr. Collins's experience.
Now, was it your understanding that Cube was trying to negotiate a PPA where service would start before Cube closed the transaction, or service would start under the PPA after Cube closed?
Repeat the question again, please.
Sorry, was it your understanding that Cube was trying to negotiate a power purchase agreement where service would start before Cube closed the transaction?
I didn't know. I didn't know if I did not know. I would assume, I didn't ask them, but I would assume that they would have thought it would be after they owned it. I can't imagine they would be trying to sell the output before they owned it. That's kind of the problem. We didn't really know if they were going to own it or when they were going to own it. And once we knew that, then we could begin negotiations with them.
Okay. So at some point you learned that Cube owned the facility, right?
Yes, I believe the closing was on February 1st, 2017, thereabouts.
And
did I say February 1st, 2017? Yeah, I meant to say February 1st, 2017. I don't know if I misspoke or not.
That's what you said, Mike.
Take a look at with me if you could at our cross examination exhibit attachment 7.
Number 7.
And I'll ask that for identification purposes, it be marked as Duke panel cross-examination exhibit number, I believe that's 7.
Would be number 7. You didn't mark the last email, but this would be number 7.
Oh, I apologize.
It will be marked as Duke panel cross-examination exhibit number 7.
This looks like an email maybe from Kendall Bowman to a gentleman to several C and DEP people. Dated, looks like 2/3/17. Is that what I'm supposed to be looking at?
Yes, sir. Yes, sir.
Okay, good. I got that up.
Before we move on, just to keep the record clean, Commissioner Clodfelter, may I mark for identification purposes the prior exhibit we discussed as exhibit number Duke panel cross-examination exhibit number 8. I know it's out of order, but I'd just like to keep it clean.
All right, I wasn't sure whether you were going to introduce that one or not, so I left that to you as to whether you wanted to mark it. So that is the email dated July 11, 2016.
Yes, sir.
Okay, and that will be then marked as Duke panel cross-examination exhibit number 8.
I apologize for that, sir. Okay, we're looking at number 7, so appears Cube, the acquisition finally goes through on what'd you say, February 1st, 2017.
Okay, I got it.
Okay, and so it looks like Cube immediately calls Duke and asks for a meeting. Is that fair?
It looks like there's maybe a press release attached to the bottom. Is that correct?
Yeah, if you look at the email at the top.
Yeah, and it was forwarded to, yes. So they asked for a meeting.
Hmm. And when they asked for, did you meet with them sometime shortly after their acquisition closed?
I don't think I did, no. I think maybe some executives did, but I don't think I did, no. If I did, I don't recall that.
Based on the prior communications you'd had, did you tell anyone at Cube that that Cube needed to submit a knock form?
No.
And why not?
Well, they closed it. They closed in February on the asset. In March, it was decided between the parties, between Cube Hydro and Duke, to enter into a letter agreement that would include both the PURPA and non-PURPA assets. So at that stage of game, there really wouldn't be a need for a knock since we were doing a non-PURPA transaction, because I think both parties were, instead of just doing a deal for the 100 megawatts worth of QFs, why don't we try to get a transaction done for the whole 200 megawatts? So there wasn't a knock form required at that time because we were doing a non-PURPA transaction.
You mentioned that Duke has been, Cube has been selling to Duke with as available rates since sometime in 2019. Is that correct?
We entered into an as available agreement with between Duke Energy Progress and Cube on April 24th, 2019. And a DEC as available agreement was executed with Cube on May 16th of 2019.
Okay. And Cube didn't submit a knock form prior to entering into those contracts, do it?
No, there's not a requirement for an as available agreement because there is no commitment. So to give you an example of how that works, it's completely different than the knock form avoided costs. As an as available agreement, it actually works quite well for the QF. Is it allows them, there is no commitment there. So at the as available agreement, so what Cube can do, or what the Cube Yadkin people can do, their traders, their marketers can do, is every day they can check PGM, they can check MISO, they can check SOCO, they can check what DEC scanner, who they could sell to. And they could also look at these as available agreements, which are basically free puts that they have. And they can choose the best prices and move their power anywhere they want to. Literally, they can flip it from DEP 1 hour to DEC the next hour and back, depending on what the as available numbers are. So there is no commitment on the QF's part. So there's no knock form required for those. Again, it's really a demonstration of our good faith to say, hey, you guys might want to do an as available agreement. You don't have to do the commitment form. And those agreements were put in place, and I think they've turned out very well for Cube.
Well, when a QF sells as available, they don't get capacity payments, do they?
That's correct, because, and that makes sense, right? Because they're not making a commitment. So to give you an example, if our next hour as available agreement is $35 a megawatt hour, and it's 22 degrees in Charlotte, and power's going for $9,000 at PGM, these guys are going to pull their power from Duke and they're going to go sell it to PGM, and they have every right to do that under an as available agreement. So that's why we don't count it as capacity. It's a very beneficial agreement for the QF, these as available agreements, because it's basically a free put. They basically have a floor in place for every hour of the year where they could put power on our customers.
Okay. Now, after Cube had finalized the acquisition of the facilities, you indicated, did you not, that the first step would be to sign a letter agreement governing what they were negotiating?
That's correct. I believe there were, I'm not 100% sure, but I believe there were meetings in maybe February, March between the executives of Cube and executives of Duke, but I was given an indication in March by our state president in North Carolina that we had agreed to enter into a letter agreement that the two parties would negotiate, and we would know them selling the entire output of all 4 output facilities to us. And we sent a draft of that, a letter agreement, to Cube on March 22nd, 2017.
I'm sorry, what was the date?
March 22nd, 2017.
Okay. And was it a condition of Duke's that to have those negotiations under the letter, Cube would not treat those negotiations as establishing a LEO?
I believe that is true, yes. I think both parties, unfortunately, it's kind of an indication of things going forward. It took us a while to get a language in place for that agreement that both parties would agree to, but both parties did negotiate this. Of course, legal counsel was involved, and I think protections were built into the letter agreement for both parties.
Do you recall what the protections were for Cube?
I don't. I'd have to read the letter. I haven't read it in a while. We did receive multiple red lines from them too on that. It was a give and take.
All right. Well, think I can say, I know you're enjoying spending time with me, but I think I can save us some time on the timeline here.
Okay.
Can you look at attachment 2 to our exhibit list,
Sure.
which I'll ask to be marked for identification purposes, Commissioner Clodfelter, as, I believe that's exhibit 9.
This would be number 9. It will be so marked.
Thank you, sir.
Okay, here we go. Okay. This is my deposition.
Yeah, that's what I was going to ask you. Do you recall giving a deposition in this case?
Oh, yes.
That was even worse, right?
It was horrible.
And if you'll flip to the back, so you submitted an errata. Is that true?
I did submit an errata, yes.
Okay. And did you testify accurately in your deposition?
I tried to. I hope so.
Do you believe your testimony was accurate to the best of your ability at the time?
Yes, I do.
Okay. And other than the errata, was there anything in your deposition that you testified to that you want to change or modify?
Well, when I reviewed the errata, I think that was the only things I remember wanting to change at that point. I haven't looked at it since December 8th, since I did the errata, which was, I think, in December sometime. But yes, I mean, I would think it would be accurate, yes.
Okay.
I'm sure not going to lie to you.
No, I don't think so, sir. And
No.
and does this appear to be a condensed copy of your deposition?
Yes.
Okay. All right. Let's let me ask you just a few more questions, then I have a few from Mr. Snyder. We're getting there. You mentioned that contract administration reviews ownership of QFs. Is that right?
Yes.
Do you know if they reviewed ownership of the QFs here in 2016?
Can you say that question again, please?
Do you know if contract administration at Duke reviewed ownership of the 3 QFs at issue in this case?
I don't know the answer to that.
Okay. And so I take it you don't know who they contacted or when?
I don't know that. I don't know the answer to that.
Okay. Mr. Snyder, can I ask you to look what is our attachment number 12, which Commissioner Clodfelter, I'll ask to be marked for identification purposes as Duke panel cross-examination exhibit number 10.
It will be marked accordingly.
Let me know once you have it up, Mr. Snyder.
Is it our Achieving a Net Zero Carbon Future, our 2020 climate report?
Yes, sir.
I have it.
Okay. And it sounds like you're familiar with the document.
I am.
And did you have a role in preparing it?
Not a direct role, but it does tie into my group with our resource plan, so I'm very familiar with it.
Okay. And is part of it, does it include a 2020 integrated resource plan for DEC and DEP?
Yes, I have a direct role in that. I'm responsible for the preparation of those documents.
And does it discuss the steps the companies will need to take to achieve their carbon reduction goals?
Yes, it does.
And is it true that Duke has announced a goal of reducing CO2 emissions by 50% from 2005 levels by 2030?
Yes, we have.
And has also, the companies have committed to achieving net zero carbon emissions by 2050.
That is correct.
These commitments are discussed in the Integrated Resource Plans, DEC and DEP filed with the Commission in September 2020 also, aren't they?
They are.
And this indicates on page 1, this exhibit does it not, that achieving those goals will require significant growth in renewables and energy storage.
Correct.
And that achieving those goals will depend on the availability of advanced low and zero carbon technologies that can be dispatched to meet energy demand.
Absolutely.
Would those include nuclear, carbon capture and storage, hydrogen power, and long duration energy storage?
Yes.
And some of these technologies are listed on page 24 of this exhibit, aren't they?
I'm seeing them on page 5. Let me go to page 24. Yes.
And there's a table on page 24. It also indicates, includes estimated cost per kilowatt of capacity for these technologies, correct?
It does.
Okay. And some advanced technologies are expected to be more expensive than traditional generation, correct?
That can certainly be the case.
Yeah. So I believe the chart indicates, does it not, the natural gas combined cycle with carbon capture and underground storage is $2,000 a kilowatt versus $650 a kilowatt for natural gas combined cycle without carbon capture.
I'll agree. That's what's in the report.
And pumped hydro storage is $2,500 a kilowatt.
I'll agree that that's what's in the report.
And modular nuclear reactor is $5,500 per kilowatt.
That's an assumption within the report, yes.
So all told, those are anywhere from 4 to 10 times the cost of conventional generation. Is that right?
I'll do subject to check. I don't think they're all necessarily, depending on how you look at the cost. But yeah, let's just say I'll say subject to check that some of these technologies are more expensive than traditional generation.
And would that be before considering interconnection costs, which might add some percentage?
Yes, we would have to look at what the interconnection cost would be.
And those are just capital costs, right? It doesn't include operations and maintenance cost or costs of fuel.
The numbers you listed were capital, overnight capital costs, I believe.
Okay. And if I understand the IRP, it's stating that the company expects interconnection of these new technologies to pose challenges.
They could, yes.
I'm sorry, go ahead.
I was just going to say each of the technologies can have its own challenges.
Okay. And on page 25, the company states that it expects these advanced technologies to be commercially available for deployment in the mid-2030s. Is that correct?
Yeah, many of these are future technologies.
So, you know, potentially the company is looking at investing in a good deal of new carbon-free generation and energy storage that's expensive, potentially difficult to interconnect, and not likely to be available for some time. Is that true?
No, I would say these are potential technologies that are out there, and yes, these are cost estimates of our best estimate at this point in time. I think as we evolve our IRPs every 2 years, we'll have new cost estimates for this and new technologies, and this at this snapshot in time, these were meant to be representative of some of the technologies and some of the costs that we're seeing today, roughly.
You know, all told, the cube QFs represent approximately 110 megawatts of generating capacity. Is that true?
Within the cube balancing area, they do. Yes.
Okay. And within the constraints of their FERC license, the cube QFs could be dispatched to meet energy demand, couldn't they?
Subject to many of the issues we just spoke about. I mean, we'd have to look at the cost to interconnect the cube assets to the DEP BA, and and then whatever cost we paid for it. But yes,
But subject to those, they could be.
potentially, they could meet the capacity needs of DEP with subject to, securing the firm transmission to make those available and subject to finding an appropriate price that's representative of either the market on the non-PERPA or the prevailing avoided cost when a LEO is established.
And the cube QFs do not generate carbon emissions, do they?
They do not. Importantly, though, they do not generate them for Cube. DEP would not get to count them as carbon-free resources under a PERPA agreement.
Say that last part again. You said under a PERPA agreement?
Under a PERPA agreement, they would not be considered carbon-free.
I understand. And the cube QFs are in their own balancing area authority, right? Which is already interconnected to the companies. So
there's a difference between being an interconnected BA and having firm point-to-point transmission that allows the firm delivery from the Cube BA, as I understand it, subject to check. Like I said, I'm not the transmission expert, but they're their own balancing area. DEP is its own balancing area. They are an interconnected BA. DEP is interconnected to other balancing areas. Simply being interconnected does not mean that resources in an adjoining balancing area have firm transmission capability to deliver firm from one BA to the other. So yes, they're interconnected BAs, but that does not assure the firm delivery of a resource into the adjoining BA.
Right. I take it then that you don't know whether additional work would be required to interconnect them to Duke system.
I do not. That would need to be studied.
And is it the case that energy and capacity from the Cube QFs is available right now?
It's the case that energy is, not capacity.
Well, not that it's being sold, but it's available.
It may not be available. You'd have to get it to be count as capacity, you need to have the appropriate transmission to make the transmission firm. When you're buying from a neighboring BA, simply having an interconnected BA does not guarantee that you can buy capacity. You have to own the firm transmission to move capacity from one balancing authority to the other.
Well, I'll put it this way. As you sit here right now, you don't know if it has, firm capacity or not. Is that right?
I would say it would probably need to be studied.
And you don't know whether there are sufficient transmission ties
to allow it to be firm without the need for upgrades. That's sort of the purpose of doing the transmission studies. It may or may not be. I'm not an expert in that, but it would need to be studied before you could deem it as capacity, and that transmission would need to be acquired.
Would having the energy and capacity on the system help Duke achieve its carbon reduction goals?
It may or may not, depending on the form of legislation. Again, under a PERPA agreement, the carbon-free attributes do not come with the energy and the capacity. So if there was federal legislation that passed that ascribed zero carbon energy credits to Cube would have the free latitude under a PERPA agreement to sell those zero carbon energy credits to someone in Virginia, South Carolina. If they sold it into DEP, it would be at an additional cost above and beyond what we're talking about, whatever price we pay for energy and capacity. So while it is a carbon-free resource, the benefit of that carbon-free resource does not transfer with the sale of the energy and capacity under a PERPA agreement.
Could dispatchability facilitate better use of intermittent resources like wind and solar?
You'd have to take a very close look at, certainly hydro is more dispatchable than intermittent resources, but it has its dispatchability limits as well due to water availability, must run, other constraints. So limited dispatchability that comes with hydro, would be better than intermittent resources. But they in and of themselves, hydro resources have their own limitations on dispatchability.
I want to go back to one thing. If Cube does have firm transmission, then it could qualify for capacity, correct?
Yeah, the transmission would need to be studied and it would have to be deemed firm, and any upgrades that may or may not be needed would have to be put in place.
But I'm asking if it were deemed firm and didn't need upgrades, it could qualify for capacity, or if those upgrades were made. Correct?
Yeah, if you have firm transmission from a resource in another BA, it can, whether it's PURPA or non-PURPA, if you have firm transmission into your BA, you can deem that as capacity.
And under PURPA, QF can enter into a contract that allows it to be dispatched, can't it?
Yes.
And in fact, Duke has PPAs with cogeneration units that are QF that allow them to be dispatched, right?
Yes, I believe they do.
Okay. Mr. Keene, I think you say on page 15 of your testimony that Duke's first offer to Cube was a 2-year energy-only transaction at market rates. So Duke didn't purchase capacity from the, purchase capacity from the facility, correct?
That's right. And the reason for that, and I think we've talked about, well, it was, I think, a question briefly about PURPA versus non-PURPA, but at that time, we were trying to do a market agreement, and we had plenty of capacity. So for us to justify a purchase like that, it has to work on an energy basis only, because we already had plenty of capacity. So that's why we tried to structure it as an energy-only transaction. The benefit is we could do the whole 200 megawatts, but we didn't have a capacity need. So that was kind of a market-based agreement, while a PURPA agreement would be more of a regulatory-driven agreement.
And do you recall Cube ever indicating that it was not receptive to a PPA where Duke had dispatch rights?
Yes.
You do recall that?
I do recall that, yes.
That Cube said they were not open to dispatch rights.
Yes.
Okay. Who said that, if you recall?
I don't remember who it was. I was as surprised as you are. I think eventually, as I mentioned before, we issued an RFP in 2018, and we negotiated all the way till April of 20 with them, with I think it was Mr. Collins's commercial replacement. And even at that stage, there were still limited dispatch rights.
Oh, if either of you know, did Duke ever perform a calculation of what the avoided cost rates Cube would have been eligible for if it established a LEO in September 2016?
Glenn, you might want to talk about the difference between, before you answer that, Glenn, though, I will tell you that on September 25th, 17, we did offer them a PURPA offer, essentially a PURPA offer, in September of 17 based on our 2017 avoided costs. And just so everybody knows, at that point, that was around $34 a megawatt hour on average. But that was rejected by Cube Hydro. They had actually 2 or 3 weeks before then had sent us an offer asking for $60 a megawatt hour, escalating at 2 to 3%, which was unrealistic in any shape. There's just no market at $60 a megawatt hour anywhere at that time. So, but Glenn may have an idea, Mr. Dowdy, as far as what the September 16 offer. I think back then it was maybe $60. I don't know, Glenn, in that time frame. And we offered him, say, 35, just to make the math easy. We offered him 35 in the summer of 17, 35. Summer 16, maybe 50 or 55. I don't know, Glenn. Maybe you have a better feel for that.
But I want to be very careful in saying make an offer. You know, what were avoided cost rates? I think we have we have filed rates, doing negotiated deals with people who did appropriately establish a legally enforceable obligation in 2016. For those periods, I believe we were somewhere in the mid 50s, plus or minus a few dollars. It, is where avoided costs were. If that's the question, I think there's we can go back and look at our filed rates for, sub 136 and see where those are, sub 140, sub 148. But as I recall, the all-in levelized cost was somewhere in the mid 50s.
So subject to check in the mid 50s, and would the same be true for October 2016 if a company established a LEO in September or October of 2016, the avoided cost rates for Duke were in approximately the mid 50s.
Before the rates were filed in 16 in November, in all likelihood that would be subject to check.
And in
Mr. Dowdy, I don't know how much more you have, but I want to give Ms. Garrett an afternoon break here. So
if it's suitable, I'm very close to finishing, but I think if it's suitable, if we could take a quick break, I think it'll make everything go quicker. It'll give me a few minutes to streamline.
Anything that'll make things go quicker, we're all in favor of. So let's take an afternoon break here. Let me also check with all council. How are we moving generally toward the afternoon? What's your prediction?
Mr. Chair, in terms of a redirect, I just have a few questions based on what I've heard so far. So I don't anticipate that it will take more than 15 to 20 minutes max.
All right, well then let's take a 15-minute break and we'll come back at 3:30. Come back on the record at 3:30. Again, while we're in recess, please stop your video and mute your microphone. I think we're missing Commissioner Duffley. Unless she's back and I can't find her.
I'm here.
You are? Okay. I think we have everybody we need then, so let's resume. Mr. Dowdy?
Thank you. All right, I'm going to try to do this quickly. We were talking earlier about the avoided cost rates in September and October 2016. Do you remember that, Mr. Snyder?
I do.
Okay. And you referenced a rate range. Is that fair to say?
Yeah, and it really is subject to check because I don't have the numbers open in front of me, but based on my recollection, I think I'm in the ballpark.
Were those the standard rates? In other words, they weren't these QF specific, right?
This was not a rate given. I think I spoke about the bifurcated process in my testimony and in my opening statement that we have published rates that get updated every 2 years that small QFs are eligible for. Larger QFs have the same underlying premises go in, but fuel prices get updated, and those prices are updated periodically over time so that as they establish a LEO, they're offered a PERPA rate that is commensurate with the avoided cost value they're creating at the time the LEO was established. But it's generally in line with the published rates, except for movements in fuel prices between avoided cost filings.
And the establishment, the avoided cost rates are determined based on the LEO date, correct?
Correct.
And is it fair to say that then, and since these were the general rates, if you will, they didn't account for whatever the specific, or they would not account for whatever the specific advantages or disadvantages the Cube QFs may have offered the system?
Yeah, I think you have to say that within the context of what is allowed within PERPA. So for example, Cube, while a carbon-free asset, would not, those carbon-free attributes do not convey with PERPA. So that specific attribute, whether it's small QF or large QF, would be fundamentally the same value, which is zero value placed on an avoided cost rate.
And is it fair to say rates have gone down since October of 2016, avoided cost rates?
Yes, it is fair to say that they've gone down. I think it's an interesting question for the commission. If they would have been moving in the other direction, would we be here today? Would you and Mr. Collins be here saying, we picked up the phone and talked to an executive and, oh boy, November rates are $70 and then the next year they're $90, but we're going to honor our $60 rates. I highly suggest that you're probably not here having this conversation. And if we showed up at the commission saying we got a phone call from Cube in 16 and therefore they're not eligible for the $70, $80 or $90 rates, we probably would have been laughed out of the commission room.
Fair enough, but in that instant, is it possible that Duke might give a different answer on how to fill out the NOC form?
No.
I want to talk about that. Let's finish there. You referenced the possibility of, I forget exactly how you put it, but crossing out section 3 and putting NA.
Yeah.
But NA is not actually a choice on this form, is it?
I've filled out a lot of forms in my day where I don't have a choice and I write over it. And many times it goes perfectly accepted.
Many times, but how would one know it would be accepted this time?
It's probably a better chance of it being accepted than not filling out a form at all.
Do you know if that's an option listed on the website to mark section 3 NA?
I think any form can't envision every potential outcome, and it's up to the person filling out the form if they have questions to ask. I think Mr. Collins alluded to the fact that he was aware this form was out there long before having conversations, and if he had specific questions on the form, he could have asked. He was aware of that form. He testified he was aware of the form, And they wanted, and I think quite frankly, you wanted to keep your option open to be able to backcast if prices went down and forwardcast if they go up. And it's commercially reasonable to do that, but that's the whole purpose of a knock form.
But just to be fair, though, you're surmising that you don't know whether that's what Mr. Collins or Cube was thinking or not, do you?
I do know that Mr. Collins just testified that he was aware that form was there before conversations with Duke.
Yeah, he was aware of the form, but again.
And if he had
I'm
questions
asking,
on the form or how to fill the form out, he could have reached out to Mr. Keene or other representatives of Duke during one of these many conversations.
well, fair enough, but when Duke was flagging issues for Mr. Collins, they could have raised the knock form too, couldn't they?
It's not Duke's responsibility. We're not the seller. And quite frankly, as Mr. Keene represents, Cube is not the seller until they own the asset. But we're not the seller, and we have many, many, many QFs that go to our website, fill out the knock form, and bring it to this commission. And if the commission has a standard of the company has to make the QF aware of the knock form, they would have put that in their order. The knock form is published on our website. It's very transparent as to what needs to do to establish a notice of commitment. Sophisticated buyers would be looking at that. Mr. Collins said he looked at that. So, I find it a little disingenuous to say it was Duke's responsibility to start raising these questions about what do I do about the CPCN before the seller even was established as a seller.
You referenced the website. Does the website mention the option of marking NA to your, crossing out and writing NA to your knowledge?
No, if it would be, it would have been on the form.
Okay. And do you know if and either of you, if Duke has ever received a form that someone marked NA?
It's not, I do not review the form, so I wouldn't have that information.
Make sure I understand your answer. I'm sorry. You don't know if it's happened, or is that what
I do not know if it's happened.
Mr. Keene, do you know?
I don't know if anyone has put NA on there. I do know that every PPA that we do has a knock form submitted before we calculate the avoided costs. And typically, as I mentioned before, if our contract management folks see that a form is incorrectly filled out or we need additional information, they will reach out to the owner and get the form corrected.
If you mark NA, what is the Leo date under this form?
The Leo date is not about when you get the CPCN. The Leo date is when a knock form is received that is deemed to be an appropriate knock form. And I think we've had a lot of testimony today about the fact that the knock form being submitted, if there was not a disagreement that the CPCN was going to make it invalid. In other words, if the public staff has said, we don't see an issue, Duke has not said that we would have invalidated that simply because you put NA, there is no reason to believe that the Leo wouldn't have been established when a owner of a facility files a knock form and the parties agree that it's, that it's filled out. And if the company would have, and I don't believe they would have, contested the NA designation, at that point in time, then the commission has an issue to arbitrate. Then the commission can say, yes, NA is right because these facilities were built pre-CPCN, something that, one of many hundreds of potential things that could potentially, you can't think of everything in a form that could make the form, an NA appropriate, and say, yes, we either agree with Cube or we agree with company that it was or wasn't an appropriate knock. But the point is the knock was never filed.
And I take it that neither of you know, as you sit here today, whether Duke would have agreed with the public staff about whether a CPCN was required.
From my perspective, I think it's reasonable to say these facilities have already predated the CPCN and they are operating facilities in good standing. And we're ready, willing, and able. We're the owner. We've pre-certified. And that's, that would have had to been too. I don't necessarily agree with Mr. Collins that the facility gets QF designation without the owner. I'm not a lawyer. I think that issue would need to be looked into, but FERC requires new owners to recertify, as I understand it. They require recertification if there's significant changes to the facility, which is part of the transfer of this ownership. There are significant changes. So I do believe, the fact that recertification of this facility under Yadkin, from Yadkin over to Cube, that didn't happen until March of 2018, also should be, a question of whether or not an actual QF has been established in Cube's name. I disagree with Mr. Collins' representation that simply certifying the facility, if that was the case, Cube or FERC wouldn't have you recertify. FERC wouldn't have you recertify with significant changes or with new owners. But as I understand it, FERC asks that these facilities be recertified under those situations. So, we haven't even brought that up, but that probably would have more likely been the contention than the CPCN.
I understand. Okay, so you referenced earlier, was it your testimony earlier that not every form covers every situation, right?
Yes. Yes.
And that led you to the conclusion that one should sort of make changes or write-overs to the form to address that. Is that right?
Or reach out and ask the public staff, ask the company.
Is one other thing that someone could do, ask for a waiver from the board?
It would probably be good if they asked for the waiver at the time they were trying to establish the LEO and not after prices have fallen and they didn't get, the highest price they could have. So when the waiver is being used as a retrospective free put option, then no, I don't think that's a reasonable option. You could ask for the waiver in 2016, in October of 2016, if you thought it was an invalid form and said, we'd like a waiver and we'd like clarification that we can establish a LEO as a non-owner. So I think the waiver is not an acceptable reason not to fill out a form.
And if you filed that proceeding, then presumably that would be a proceeding that other people could get involved in, intervene, or the company could contest, right?
Well, I think the commission would need to determine whether a non-owner at that point in time could establish a LEO, because it is a very complex issue. There may be 3 people bidding on those assets. And what if they all at different points in time tried to establish a LEO? I don't know how the commission thinks about that. I'm sure you are not the only prospective bidders on the Alcoa assets, and therefore multiple people could be looking to establish LEOs at various points in times in negotiation. It seems unwieldy and unmanageable that would actually be how a LEO gets established.
But proceeding in that, and I think this is my last question, proceeding in that manner then wouldn't necessarily create the certainty that the NOC form is intended to create.
That's why a NOC form can't be filled out by a prospective owner. So it certainly creates the certainty as long as the owner is the only one that can fill out the NOC form.
Well, and there's no section they need to cross out, right?
Don't think they needed to cross out. They just need to ask for clarity.
I don't have any further questions.
Redirect, Mr. Chairman.
Yes, redirect.
Thank you. Just following up, Mr. Snyder, on that line of questioning, you said several times that the NOC form is filed. It's not, actually not filed with the commission. Is it? It's actually handed to Duke. Is that correct?
That is correct. I'm sorry if I misspoke.
And you were asked a series of questions about the timing of whether or not Cube would have been eligible for the avoided cost relief prior to the November 2016 change versus what those rates would look like after that change. Can you give us a magnitude in dollars of what we might be looking at, or the commission might be looking at in terms of what customers would have to pay if it's established that they are entitled to those pre-November 2016 rates.
I heard Mr. Collins testify, and I jotted it down, that the three facilities that are in question produce about 400,000 megawatt hours a year. We're talking differences in rates of, for round numbers, $25 a megawatt hour. So you're looking at $10 million a year of overpayment times a 10-year contract, let's say, be $100 million of costs that customers would pay that are above current rates.
And as you said, the customers pay that, not Duke Energy.
Yeah, this is always Duke is the middleman here that collects dollars from customers and gives those dollars to the QF.
This would be for the panel. I'm not sure if you want to answer it, Mr. Snyder or Mr. Keene, but we were asked to look at the exhibit, which was the press release showing that the facility had been purchased. Do you recall that? One of you?
I remember looking at that press release, yes. Mike, I don't know.
Yeah, I remember looking at it, but I don't remember which
I believe that was Exhibit 7.
Okay, let's see, Exhibit 7.
It was
the Kendall Bowman email with I guess, an attachment, it looked like.
Yeah, my question is, in the next last paragraph of that press release, it talks about how all the fight among the counties, the cities, state government, and ownership of the Alcoa facilities were now over since the purchase by Cube. My question is, doesn't that indicate that in that time frame in the fall of 2016, there was still uncertainty as to who might own those units, and that you were right in your position that you don't talk to someone unless they actually own the facility?
Yes, I guess there was still some opposition at that time. I know, we had seen documents that the North Carolina Department of Justice was involved also. But again, it's just a lot cleaner for us to not try to guess who the owner is going to be or when their owner is going to be. So from a business perspective, we wait till we know who actually owns the plant. And on January 31st, 2017, it was owned by Alcoa. The next day, it was owned by Cube Hydro. So that's how clean it is from our perspective when we're dealing with counterparties like this.
And Mr. Keene, I believe you were asked a question about the ability of Cube to dispatch the unit. Did they ever indicate to you that the units would be dispatchable?
Yeah, I mean, that's a good question, and got that earlier. So on September 5th, 2017, when we got our first offer from Cube Hydro, they wanted to sell us the full 215 megawatts for 15 years at $60 a megawatt hour, escalating at 3%. In that agreement, it states in that agreement that Cube Hydro has full scheduling and dispatch rights, and Duke would only be able to dispatch the unit in an emergency condition. At that pricing of $60 a megawatt hour for 15 years, that would be about $150 million over our summer of 2017 avoided costs.
Thank you. That's all the questions I have of the panel, Mr. Chairman.
All right, let's see what questions we have from commissioners. And I'll begin again with Commissioner Brown-Bland.
Mr. Keene, good afternoon. With regard to the letter dated September 21st, 2016 to John Collins, in that letter, you indicated that the Yadkin system was not owned by Cube, essentially. It was owned by Alcoa, correct?
Yes, ma'am. I mean, yes, Congressman.
And then you indicated at the end of that second paragraph there. That's okay. It's late.
Sorry about that.
That's okay. You indicated at the end of that paragraph that you had informed that to the extent that Cube was considering working under PURPA or certifying the units under PURPA, that it was Duke's position that Duke likely had no PURPA obligation. Is that a fair?
Yes, there was at that time, before they owned the assets, there was some conversations internally with legal counsel that that we might be eligible for the organized market exception under PURPA. And it was something that I wanted to make sure that Cube Hydro knew that we were discussing about and gave them a chance to do their homework also. I think in retrospect, we decided not to exercise that right and go to FERC and ask for that. And I don't think, we never made a decision to go forward with that, but we wanted them to at least know that it was a conversation we were having and make sure they had read that section of PURPA. But we ended up, and what eventually happened there was we, once they owned the plants in February, by later that summer, we basically gave them a PURPA offer. So the organized market exemption, the NOx stuff, it kind of became moot because once they owned it, we basically gave them the 2017 summer offer and they rejected that.
But here in this letter, September 21st, that statement regarding PURPA is not necessarily tied to the statement right up above it that Duke does not have any current needs for energy capacity.
Yeah, the reason I mentioned current needs is because there's really two paths you can take if you want to do a long-term agreement. You can take the PURPA path, which is sort of a regulatory process that we're talking about today, or you can take the market case. And basically, I was letting them that we didn't really need any capacity and energy at that time, but that when we did, we would issue an RFP for that. And then when we do the RFP, we get competitive solicitations and we can prove to ourselves and to you that we're out buying the cheapest available capacity and energy out there and getting the best price for our customers. So, and eventually we did that in 2018. We went the non-PURPA path with them. It just didn't work out because there was a couple thousand megawatts in the market cheaper than that. But the one thing we mentioned to them was that these things were not certified as FERC as QFs yet. And then a week later, they went and got them certified. Alcoa did.
Okay, so you got ahead of me just a little bit there. So what I'm driving at right here is those two statements about having no need for energy or capacity, and then the issue that you likely didn't have a PURPA obligation. Those are two separate. They're not tied together as two separate concepts, correct?
They are two separate issues, yes.
Okay, and then where you were going is where I was going to go. Well, let me come back to that. So,
sure.
You when did Duke first decide to negotiate or make any proposal to Cube?
I think the decision was made in March of 2017. The following, they owned them in February. And I think in March, we decided to go forward and negotiate with them at that time. And throughout that summer, we traded. We sent them 2 offers and they sent us 2 offers. We just weren't able to agree. We were very far apart. We were at avoided cost about $34 and they were in the $50 to $60 range. We were just very far apart.
And so prior to that time, or sometime in 2017, Duke did not negotiate or entertain negotiations with Cube, whether it was PURPA or non-PURPA, correct?
Can you repeat that question, please?
Duke didn't negotiate with Cube prior to 2017, either PURPA or non-PURPA.
That's correct. We did not, I mean, we had a lot of conversations, a lot of meetings, a lot of letters going back and forth before they owned it, but I wouldn't classify those as negotiations. I think once they owned it in February, it was at that point we started sharing pricing data and began negotiations with them.
And coming back to where you were a few minutes ago, at some point, it's not in this letter to September 21st, but I just heard you, understood you to say at some point, Duke told Q that these facilities were not QFs?
They had not been, at the time of the September 21st letter, they had not been certified at FERC as QS. And then a week later, Alcoa did file the FERC Form 556 to get self-certification. So it was done in September 28th.
And
by
so,
Alcoa.
do you recall that to just have been a oral conversation, or was that in writing? And I just don't remember if you know. When you
You're talking about when
indicated that it was not a QF, when you indicated to
Right.
Q that it was not a QF.
It was done both in writing and verbally.
All right, and then you said a week later?
Yes,
Was it a week
September
later?
28th, 2016, or right around that day, Alcoa self-certified 3 of the 4 facilities at FERC.
All right.
That was even though PURPA had come around in 1979, 78, that was the first time these 3 power plants were ever certified, as far as we can tell, as QFs.
Now, if it doesn't have to be Cube, and it doesn't have to be about what was going on here. This is just my general question on Duke's practice. If you were going to sit down and enter PURPA negotiations, and you were seriously trying to get to some end result there, would you have indicated to the party you were negotiating with, in this case, if it's going to be PURPA, it would be a QF. Would you have indicated to them what Duke would be looking for, what Duke would need to go forward?
Yes, we would. Like I mentioned earlier, we just had 4 hydros start March 1st. We got 4 more starting March 15th. When they reach out to us, they submitted their knock forms. We checked them, put them in the file, and then we calculate our costs based on those, get them a PPA, and then the agreement starts. We get a rec agreement at the same time. So that's the case. What happened with this one was sort of in March of 17, we were doing a non-PURPA agreement because they wanted to sell the whole 200 megawatts and we wanted to buy the whole 200 megawatts. So we initially started in March trying to do a non-PURPA agreement. That eventually didn't work out. They didn't like our pricing. So in then September of 2017, we offered them basically a full PURPA agreement based on the 2017 avoided costs. And what they wanted is the avoided cost before mid-November of 2016.
But if with any QF, if all the elements were there, you were trying to be serious to get to a PURPA based agreement. It's not Duke's practice not to. You don't try to. I realize that the knock is on the website, but if you were sitting down with personnel and talking, you think it would have at least come up?
No, I mean, there's no way we would do that. I mean, you hear people.
No way you would do what?
There's no way we would that we wouldn't interact or communicate with people who want to be a PURPA and sell to us. Okay. I mean, we would, and we do this all the time. Like I said, we have 60 small hydros that we deal with all the time. We work with them as closely as we can to get these done. A lot of these are mom and pop operations that are filling out their knock form on their kitchen table. I mean, we're trying to meet our obligations at all times here. When you hear people talk about bad faith negotiations in here, I've been the commercial representative since the beginning, and I don't negotiate in bad faith. We tried very, very hard to get a deal with these power plants, and literally just stopped negotiating a non-PURPA deal with April of 20. And the only reason we did that was we just couldn't get past the pricing hurdle.
All right, and so it's not some directive or practice of Duke to hide the ball regarding the not requirement, correct?
Not at all. No, ma'am. We would not know.
Now, if let's say in this case, if Cube had submitted the notice of commitment form, and that we weren't here talking about a waiver and no waiver was needed, but the rest of the facts remain the same. The sale had not closed and that kind of thing. Would Duke have negotiated with Cube?
Would we negotiate with them if, would we negotiate with them if they never owned the plant?
Right, but the fact that I'm changing would be that they would still not own the plant, but they would have submitted somehow submitted a NOC form prior to 2017.
Oh, okay, yeah, no, I mean, we would not accept the NOC form from a non-owner. If the NOC form, before they owned it on 2/1/17, if the NOC form had come from Alcoa, we would have moved forward and put a PERPA deal in place with PERPA at the time. And whether or not that agreement was assigned once the sale was done, I don't really know how that would work. But if Alcoa approached us in the summer of 16 with a NOC form and they certified the units as QFs, we would have calculated our avoided costs at that time and presented them a PPA with that.
All right. And at any time, or were you ever provided with the purchase agreement between Alcoa and Cube?
No, ma'am.
And at no time, did you happen to see it, or was it ever reviewed by Duke, that purchase agreement?
I can't say if anyone at Duke had ever seen it. I can tell you I never saw it. I never knew what the closing requirements were. I know that I was never reached out by Alcoa at any time at all, not one time. I've never talked to anyone at Alcoa.
All right. No further questions. Thank you.
Okay, Commissioner Gray.
Thank you for the day, but no further questions.
All right, thank you. Commissioner Duffley.
Have just a few. Good afternoon, gentlemen.
Good afternoon.
Good afternoon.
So, Mr. Keene, you testified today about the 60 small hydro PPAs or hydro facilities in North Carolina, and you also mentioned that 4 of those have just recently submitted, I think I heard this, NOC forms. And just in the context of other similarly situated entities to Cube, were any of these small hydros in the same situation as Cube? And how did those negotiations go?
Yeah, we have 4 that just started money. We got 4 more starting March 15th. Negotiations go fine because I think we explain how it works. They know that they have to submit the NOC form. They know that if they're, less than 1 megawatt or 2 megawatt, depending on which state they're in, they get the standard agreement. And if they're not, then we negotiate a rate based on those avoided costs and we give them a PPA. It goes pretty straightforward. Typically, the biggest discussion is the term. Some like a 1-year term, some want a 5-year term, some a 10-year term. So we have to work within the regulations to get them the term that they like. So a lot of times we'll calculate a different term for them if they want to look at, different costs. But for the most part, they go pretty straightforward. We include with that, typically you have the PPA with the avoided costs in it. You have an interconnection agreement and you have a REC agreement. So we will buy RECs from these because they do meet new renewable energy facility status. They're less than 10 megawatts and that. So we can buy RECs from them. So typically with these customers, we have 3 agreements in place with them.
So none of the facilities were built prior to the institution of the CPCN statute?
Not the ones I've dealt with recently. Most of these are very old units, older, smaller units. But we do have, frequently we do have assets. Those hydro assets do end up on the market occasionally. So our contract administration people, they have the difficult job of making sure we're sending the invoices to the right owners because these things do get sold and passed down and things like that occasionally. So we have folks that, have to, do the paperwork for change of ownership and change of control and things like that. But these are, well, most of these none of these really have their own balancing authority. These are small plants that are either within our system or an adjoining system. So they don't have like their own transmission and stuff. So that's a little bit different. You don't have the extra sort of non-PERPA unit either, but.
Mr. Keene, I'm going to redirect you to a different question or a question, similar question. Mr. Snyder was asked about, are there similarly situated facilities in North Carolina, and he answered that he was not aware of any. What is your answer to that question?
Well, could you please just make sure I answer your question correctly? What do you mean by similarly situated?
That they were built and put into operation prior to the CPCN requirements.
Oh, yeah. Almost all these small hydros were put in place before that. So I would say almost all of them.
So how were those other hydro facilities able to fill out the not form?
They, and I'd have to go back and look. I did glance at some of them. Some of them just leave that section blank. You know, our contract administration people are fine with that. The plant, when you have a plant that's been around for 50 or 60 years, the CPCN doesn't really, you know, well, I don't want to get into that, but yeah, they fill out the forms and just leave that area blank typically.
About how many facilities that you're aware of that have just left that portion of the form blank?
I don't know the answer to that. I'd have to go back and look, or have our contract people do some research on that. You know, while we were on break, I went and pulled up some and to just check these 8, and we have knocks for all 8 of them.
Okay. I'm going to switch to the exemption, the claim for the potential exemption to purchase.
Sure.
I've heard you say that you researched it. Why did you make the decision not to move forward with filing with FERC for the exemption?
That's a really good question. There was a couple of things. One is entering into a hydro facility at avoided cost is, you know, we consider that to be a good thing. I mean, so it wasn't like we didn't want to buy the output, we did. So I think that was part of it. There was some question on whether FERC would agree to it or not. So we decided just to basically move forward, and once we were not able to make a non-PURPA agreement with them, that's why we offered a PURPA agreement, essentially a PURPA agreement in September of 17. But the real answer is we're not sure FERC would agree, and 2 is we're kind of indifferent at avoided costs. We're supposed to be indifferent at avoided costs, because if it's calculated right, it shouldn't be below our costs, it shouldn't be above our costs, it should be right at our costs. And locking up some hydros at our avoided costs, that's not a bad thing. We like our 60 hydro PPAs, and we like our 26 facilities in the Carolinas, our hydro facilities. So, and these are good power plants.
Okay, and you mentioned the PURPA agreement that you've currently entered into. So since it's PURPA, I assume the Narrows facility is not part of the agreement. Do you have a separate contract or agreement with respect to the Narrows facility?
No, we do not. I'm not aware of any agreement between us and Narrows. As we mentioned earlier, we do have a DEC as available agreement and a DEP as available. Those are PURPA agreements, and those are in place with the three PURPA machines. But I think Narrows is one where Cube is probably playing the market with that, so they're selling to, you know, each state to maybe the highest bidder or something like that. But we don't have that one tied up in any agreement as far as I know.
Okay. And then you mentioned the 2018 DEP RFP. What are the sources of generation for the 1,800 megawatts? Is that right? Secured in that RFP?
Yes,
the sources of generation.
So we did issue that in 2018. We got about 20 bids in. We did 5 PPAs. One of those is a peaking purchase from NCMC in DEP's territory. The other 4 machines are located in DEC's territory. And those agreements are Southern Power WAN combined cycle, Southern Power WAN combustion turbine, the Broad River peaking site, and the Southern Power Cleveland 4 peaker.
So they're all natural gas?
They're all firm dispatchable natural gas, and all the peakers are dual fuel, so they can run on liquid fuel also.
Okay, thank you.
Commissioner Duffley, just to expand briefly on that, many of those were machines that we've been buying from, that contracts were expiring and they bid competitively into the RFP and purchase power obligations that we'd already been in place with them.
Thank you. So, Mr. Snyder, I have, or both of you can answer, but Mr. Snyder, I have one hypothetical for you. So let's say Cube submitted the NOC form the day after closing on February 2nd of 2017. Is it your contention that the LEO would be created on that date, or was there some other outstanding item?
Commissioner Duffley, you know, from my perspective, and you know, obviously we would review it and see if we believe the LEO was, the NOC form was sufficient, adequate. As Mike pointed out, I don't see where we would have had a contention with the CPCN portion that's been so greatly debated today. I do personally think what would need to be reviewed is, you know, had they self-certified and had their self-certification on that date, then I think we'd have been all set, right? If on February 2nd, they received a self-certification in Cube's name and they filled it out and they submitted it and they left the CPCN portion blank and they committed to sell the output as the owner of the asset on February 2nd, I think you're golden and nobody's here today. I think the fact that it never got filled out, I think the CPCN is not the issue. I do think it's worth thinking about the self-certification process that Cube went through on March of 2018 to recertify the facility with FERC, given FERC's regulations to say if there are change in circumstances and the asset, you need to recertify. And if that's change in ownership, if that's significant modifications, I think that's where, you know, we'd like to see the self-certification in the owner's name. So had they recertified instead of in March of 18, had they recertified that facility on February 2nd of 2017, and they then committed to sell the entirety of the output, committed to pursue getting the transmission upgrades that will be required to fulfill that obligation, you know, I think we're golden at that point, and the NOC works as it's supposed to. It's the non-submittal of the NOC that created, you know, the issue. And had we had these debates timely back then, we would have, I think, resolved those rather expeditiously, rather than waiting and saw, you know, years down the road to just having not filled it out.
Okay, thank you. I have nothing further.
Thank you, Commissioner Hughes.
No questions. Thank you.
All right, Commissioner McKissick.
Thank you, Mr. Chair. Yeah, I do have a couple of questions. And Mr. Snyder, perhaps you are best able to help me with it. I was going back to the order that was entered by the commission back on December 12, 2015, where they first brought up the use of the and was it your understanding, based upon the way this order was entered, drafting, based upon discussion that was in the order, that the use of an NLC form was mandatory, where it was absolutely required, it was not discretionary? I mean, what was your understanding, and do you need to review it to?
No, it was my understanding that it was mandatory, that the NOC form is what was needed to establish the LEO. Commissioner, I would say that your body was the sort of leading in seeing that this has been problematic for years in North Carolina. North Carolina then's legislature went and saw other reforms needed with PURPA. and had House Bill 589. The FERC recently made FERPA reforms in July of last year, given the issues we've seen in setting a fixed price avoided cost rates, some of which are to deal with the LEO, some of which are doing with stale fixed energy rate. You know, North Carolina has a long history of running into these types of issues. And having a voluntary knock form doesn't do much to solve it. So my read of that was knock form is what establishes the LEO. It works both ways that way. I've been on, like I said, I was in the arbitration proceeding a decade ago. It's a little bit of deja vu here for me. In that 2011, I sat before this commission before a knock form was put in place with the EBCOR assets, and it reduced the commission to a very difficult situation of, like, I believe, like looking through board minutes trying to figure out when did this LEO get established? You know, there's no clear standard. You know, and like I said, if we were the other way today and avoided cost rates were going up, and the company came in and said, hey, they started calling us in 16, we want those lower rates, I think you would see Cube on the other side of the argument saying we're entitled to rates all the way up until we signed our knock form. So I think the knock form protects you in either direction, from rates going up, from rates going down, buyer, seller. It takes all this subjectivity that we once again are here today going through, reading through emails, reading through letters, trying to say this email to this person constitutes a LEO, is exactly why the knock form was put in place. And if it was voluntary, it would neuter that effective use of that. So my interpretation was the knock form in that 2015 order eliminated that ambiguity and was the both to the protection of the buyer and the protection of the seller, the unequivocal point at which a LEO gets established.
And just a little follow-up. Do you have access to that order? I believe it was.
I do.
Okay.
I have pages. Yeah, I think.
Can you turn to page 51?
Okay, let me make sure. Oh, I have subsets out of it, and I only have through page.
I see.
I'm sorry. Wait, let me look, see if I can have it in another.
Point of this. It's shown as exhibit across exhibit number 14, which was.
Commissioner McKesson, may I
Yes.
ask, are you referring to the order in sub 140 that declared that
Yes.
the knock form was made mandatory? I believe I sent that to Mr. Snyder, but I can.
I see it now. Is it cross exhibit 14?
Yeah.
Yep. Page 51.
Can you turn to page 51?
Yes.
I'm there, sir.
And you see the first paragraph underneath discussion and conclusions.
I do.
Can you just read that briefly and let me know if this is consistent with your recollections relating to the NOC form being mandatory?
The commission concludes that the use of a simple form clearly establishes QF's commitment to sell its electric output to a utility, to establish the notice of commitment to sell prong for creation of a LEO, would provide clarity both to the QFs and the utilities and reduce the number of disputes between the parties and the number of complaints brought before the commission for adjudication as to when the LEO was established. The revised form was submitted by Dominion with its reply comments, contains the information necessary to satisfy the of the LEO test and should not be unduly burdensome for the QFs to complete. As such, the commission finds that the use of the form should be mandatory.
And is that consistent with your recollections?
That is consistent, sir.
Now, was there any exceptions made in this order and any subsequent orders relating to facilities such as the hydro facilities, which or being sold in this case that predated the need for a CPCN?
Not to my recollection, sir.
All right. And I believe you might have stated earlier, oh, no, I believe it perhaps was the other gentleman, Mr. King, stated earlier, they're aware of 8 hydro facilities or facilities that predated the requirement for CPCN that did submit. Is that correct? Mr. Keene, is that what you stated earlier?
Yeah, we have 4 that just started March 1st. We got 4 more starting March 15th, and they all submitted knock forms. And they're all old, I would call them legacy hydro units.
Okay. I think you guys have answered all the questions I had with the questions you provided to prior other commissioners. So thank you. I don't have any further questions at this time.
Mr. Keene, one question for you. The sequence of events that we've already had established is that QBAD can recertify with FERPA these QFs, and the date we have is March 9, 2018. That was, just for reference purposes, that was about 2 weeks before they filed this complaint. My question to you is, when you made the PURPA offer in the fall of 2017 for the 3 QF units, was there any discussion then of the issue of recertification or the need to recertify under?
Yeah, let me ask you that question, Commissioner. So I actually, during this process, I had in my timeline that they had certified in March of 17. And when we were preparing for this, I actually found out it was March of 18, which I was really surprised that they still take one. But the offer we did in September 25th, 2017, because they believed, they told us that they could get new renewable energy facility status from the commission. We told them we didn't think you could, but we said, if you did, we'll pay you $4 for the RECs, $4 for each REC. So as Glenn had mentioned earlier, because it's a PURPA agreement doesn't allow you to sell RECs within the PURPA agreement. We basically, in that September 25th, 2017, it basically was a non-PURPA offer based on the PURPA avoided cost being calculated so that we could also include the RECs in the agreement.
I think I understand that. So the issue of recertification wasn't even.
Well, and I apologize. And I had it in here as they had done it in March of 2017 and didn't figure out until it was March of 2018 till while we were preparing for this in the last couple of days. I was really surprised that it took that long to happen. It really should have happened right away. It should have happened right away.
All right, thank you. That's all. All right, we'll go back and see if there are questions on the commissioner's questions. And Mr. Dowdy?
Can you hear me? Okay.
Yes, we can.
Thank you. Only 3, I believe. Speaking about the cube recertification or amended certification. I'm sorry, my exhibit went down. Bear with me just one minute. I apologize, everyone. This is going to be quickly. While I'm waiting for that exhibit, Mr. Snyder, will you take a look with me at, we looked at page 51 of what was our attachment 14?
Yes.
And Commissioner Clodfelter, since we're discussing it, I know we have judicial notice of it, but
We have judicial notice. The commission takes judicial notice of its own orders and its own filings, so it's not necessary to number those as exhibits.
I will spare us the doing of it then. I just wanted to check with you. We looked under discussions and conclusions at the under the first paragraph. Do you see the second paragraph as well?
I am looking at it now. If you give me a moment to read it, unless you want to direct me to a certain sentence.
Well, just look at the first sentence. It says, in regard to the fifth section of DNCP's revised form, the commission finds that while the acknowledgements contained therein are not necessary for establishment of a commitment to sell, they provide a QF notice of how the date of a LEO will be established, which should serve to reduce the potential for disagreements between QFs and DNCP. You see that, don't you?
I do.
And if you recall, section 5 was the section we were talking about that referenced the CPCN and when the LEO date was established in reference to it, correct?
I do.
Okay. And then, I've finally been able to pull up what was attachment 6. Let's see, cross number 5. All right. And I wanted to, the filing date we discussed earlier was 2019, but I did want to point you to the effective date if I could, Mr. Keene or Mr. Snyder, whoever's willing to answer my question.
Yeah.
This would be number 11 on page, it's PDF page 6. That states what the effective date of the form is.
Yes, I'm happy to. Subject, I mean, we can do it subject to check if you just tell us what it says.
I don't want to take up everyone's time. It says 2/1/17 is the effective date that it's being.
Yeah, I think that is the question that I would have for review, which is backdating a recertification by 13 months may or may not. I'm not a lawyer. That's my point. It's surprising that you can backdate. I'm going to recertify and ask you to backdate it by 13 months. Maybe that's FERC practice that's acceptable. Maybe it's not. I don't know. It surprised me. I saw that date. You filed for recertification in March of 2018, and you backdated the as effective date by 13 months. My earlier testimony said, had you filed it on February the 2nd, there would have been no need to backdate it. I don't know how you can backdate it to something before you owned it, but that's something you file. You know, it's a self-certification. I don't think it gets, you know, unless contested, I don't think it gets a lot of review at FERC.
And last question, I believe. Mr. Keene, you testified about, how many did you say, 8 hydro facilities that had submitted NOC forms?
No, we have 8 from this month, from this 2 weeks. And the first 2 weeks in March, we have 8 of them.
You have 8.
I have 4 on March. I have 4 that start on March 1st and 4 that start on March 15th.
And those are all hydro facilities?
They're all small hydros.
What do you mean when you say small hydros?
What I mean less than 10 megawatts when I say that.
Okay. And when you say old, I mean, do you have a sense of when these were constructed?
I'd have to go back and look at the 8 individual ones, but it was decades ago. Most of them are, textile mill type hydros, and from, I would call them legacy hydros. There may be a few new ones in there, but we haven't had very many new ones be added that I'm aware of. But I don't know the dates of all of them. Like I said, we have between, I'd say maybe 55 to 60 total.
And since they came up in March, I presume that's why, you know, if we asked about them in discovery.
It just happened to be kind of a coincidence that we have a bunch coming up right now.
And was it your testimony? I didn't understand one or the other, that none of them have CPCNs?
I don't know. I'd have to go back and look, but they're pretty old legacy units, so I suspect they probably don't.
But you don't recall one?
I just went and confirmed that they had all submitted. I wanted to make sure during the break, I just want to make sure we had knock forms for all 8 of them.
But you confirmed that you received knock forms, but you don't know whether they had CPCNs or not.
That's correct. I don't know that.
Okay. And, okay. I don't have any further questions.
All right, Mr. Kaler.
Just a couple, Mr. Chairman. I believe Commissioner Brown Bland asked you, Mr. King, a question, and I think the question had to do with, do you give legal advice to developers? And I believe, I don't know if you answered that correctly, but do you in fact give any legal advice to developers?
No, I don't. And I will just say one other thing. That's the tricky thing about PURPA. Usually when I'm doing non-PURPA deals, there's not a lot of legal issues or attorneys around, but PURPA deals are both kind of legal and regulatory driven. So again, I have to be really careful about giving people advice on, you know, especially the regulations in North Carolina, South Carolina, and Florida as they implement PURPA can change frequently. And it's really the responsibility of the owners to keep up with those. It's not, I mean, you can imagine me trying to give them advice and then it turns out to be wrong. That wouldn't be good. So it's really their responsibility to keep up with all the regulations. And that's typically why folks like Cube Hydro, you know, hire outside counsel to manage that for them.
Thank you. Mr. Snyder, you responded to a question from Commissioner Duffley. And I believe you stated something along the lines that if Cube had recertified in February of 2017, there wouldn't be an issue here. You weren't implying that if they had recertified in February of 2017, they would be eligible for the avoided cost rates that came under the sub 140 docket, meaning those rates that were in effect in the fall of 2016 up until you refiled in November of 2016.
Oh, absolutely not. To be clear, that would have been a LEO that would have been established when the knock form was filed in February of 17. They would have been able to establish that LEO.
But when you said no issue, we don't know that Cube might still have disagreed with even being eligible for the new rates that were filed in the E100 sub 148.
Because they went down, I'm guessing they may still have. Had they gone up, I'm sure they would not have.
So the final line is there could have been an issue, in other words.
Yes.
Thank you, Mr. Chair. That's all I have.
Okay, at this point, Mr. Kaler, unless there is objection from Mr. Dowdy, the commission will receive into evidence the exhibits attached to the pre-filed testimony, the panel witnesses marked and designated as they were marked as pre-filed, but without the confidentiality restrictions. And Mr. Dowdy, speak now or forever hold your peace. All right, they will be so admitted. And Mr. Dowdy, by my count, we have from you exhibits, cross-examination exhibits 1 through 10. And unless there's objection from Mr. Kaler, the commission will receive those exhibits into evidence also, again, without any confidentiality designations.
No objections from Duke.
No objection from Mr. Kaler, so they will be so admitted. All right, Duke, anything further?
That completes our testimony in this matter, Mr. Chairman.
All right, Mr. Dowdy, Mr. Harris, Mr. Snowden, as I understand the rebuttal testimony that came in on your principal case with Mr. Collins, and so there is no rebuttal. Is that correct?
That is correct.
All right. All right, that brings us down to anything before we sort of set the schedule for proposed orders. Anything else we need to talk about?
Not from Duke.
And not from Cube also.
Great. I want to, on behalf of the commission, I want to thank all of you for very efficient presentations today and also for getting your materials to us in advance in an efficient way. We greatly appreciate it. I think it's made the day a lot more bearable and might I even say enjoyable for everyone. So, all right. Is there any reason to have any different deadlines for proposed orders than would normally be the case 30 days after the transcript?
That would
We're
be
agreeing
fine.
with that.
All right, then that's what we'll do. Anything else? Anyone else needs to bring up? All right, if excuse me, yes, shame on me. Mr. Kaler, Ms. Fentress, I think it would be useful, given that there was some discussion about the subject, and I understand there may be confidential information in the NOC forms that Mr. Keene was talking about. So let's not have the NOC forms themselves filed. I think it would be useful for the commission to have a late filed exhibit in which Mr. Keene summarizes how many of the 8 small hydro facilities that he started here in March, the 4 on March 1st and the 4 on March 15th, how many of those have listed CPCN dates in the NOC forms that they submitted, and how many have either nothing indicated for CPCN or have indicated that they don't have a CPCN or that they predate the CPCN requirement, or words to that effect. Just to get a summary. I don't think you should file them because there may be other confidential information in them. There's no reason we shouldn't have to worry with that.
I think we can do that without any problem.
Right? I think that would be useful as a late file exhibit. So anything else? If not, we will close the evidentiary record subject to the request for late file exhibit. Mr. Kaler?
It was good to see everybody on camera today. It's been a while since we get to see each other, and especially Commissioner Gray. Haven't seen him in a while.
Mr. Kaler, I want to know when we're going to be able to watch you play golf virtually.
I'll let you know.
Right. Thank everybody. We are adjourned.
Thank you.
Thank you all.
Thank you, commissioners.
John, I don't know if you can hear me. I just want to say thank you as always. Have a good night.
No problem. You too.
Hey, John.
Yeah.
This is Hubert. I've been kind of multitasking pretty much most of the day, but is it complete?
Yeah, we just ended it.
Okay, I couldn't tell. I heard everyone leaving. I just wanted to make sure. So, do you still need me to follow up tomorrow with the tech check, or are you going to do that?
Oh, I'll do that. No problem.
Okay, just want to follow up, man.
Sure.
All right. Have a good one.
You too.
All right. Bye-bye.
Yes.